I can say that he was deceased.
Okay.
Or at least based off the video evidence and then what Dr. Burson said.
Okay. And as we've heard and we've seen, his phone traveled to the area of 4532 First Street Road in Greeley at approximately 6:13 in the morning,
Correct.
which means if he's, again, deceased, someone else presumably has his phone.
Correct.
And that's really what sort of jump-started your investigation, or a big significant lead. Is that fair to say?
It was a big lead, yes.
And this case is approximately 3.5 years old at this point, right?
Yes.
And after all this time, Mr. Dickerson's cell phone has never been located.
No.
And you've had opportunities to talk to his father, Alan Dickerson, right?
Yes.
Many times, right?
Yes.
His mother, right?
Correct.
His roommate that we've heard about, Mr.
Yes.
Lamming.
Yes.
No one ever mentioned anything to you about a second phone being missing, correct?
No.
The only person who mentioned a second phone, or Mr. Dickerson even owning a second phone, was Ms. Varela.
That's correct.
And Ms. Varela told you about the second phone as part of her proffer, right?
Yes.
And specifically a claim that Ms. Rodriguez stole 2 phones from Mr. Dickerson.
Correct.
And that's just not supported by any other evidence that you've obtained throughout the investigation.
No.
And as you testified yesterday, because of the initial efforts in the beginning of the investigation in terms of the video surveillance, the license plate readers, you knew that there was these 3 individuals in Mr. Dickerson's house.
Correct.
There was only those 3 individuals in the house.
It's the only ones I saw in some video surveillance.
Correct. And so I think you testified yesterday that essentially who was in the house was never really, after that initial part of the investigation, was never really up for debate.
As far as did I believe there was anybody else in the residence?
Correct.
No. After I reviewed video surveillance, I didn't see anybody else coming in and out other than those 3 individuals.
And by the time November 11th comes around, you know who is in the house.
Yes.
And so that means if Mr. Dickerson's one phone is missing, it's either Ms. Varela or Ms. Rodriguez who took it, right?
Correct.
Especially in light of the movements of the Google location.
Correct.
And as the detective, the lead detective on this case, you're trying to figure out who took it, right?
Between the 2?
Yes.
Yeah, well, I know one of them took it. Yes.
Right. And so as a detective, you routinely apply for search warrants, as we've heard, right?
Correct.
And you wrote numerous search warrants in this case.
I did.
And search warrants are a really effective tool because you can just secretly get it and then show up to a location unannounced and search the location.
Correct.
There's certainly nothing public about when you apply for a search warrant, right?
No.
In fact, it's designed to be secretive, the process.
Correct.
And designed to give you as law enforcement sort of definitely the advantage of surprise.
Correct.
So that people don't have the time to destroy evidence, right?
Correct.
There's no risk of losing the evidence, right?
Correct.
And you got a search warrant for Ms. Rodriguez's brother's, or the family residence at 4540 First Street Road.
I did, yes.
And that was obtained again in secret.
Yes.
There was no way Ms. Rodriguez or her family would have known that you guys were getting a search warrant, right?
I hope not.
Right. If this right. I mean, do you know of any way that they would have known?
Not unless that information was leaked, and I don't believe it was, so no.
By a judge, right?
Or the courthouse, but no, I don't presume that happened in
Okay.
this circumstance.
Okay. And so the search warrant was executed, correct?
Yes.
Numerous trained and skilled members of the Greeley Police Department searched the residence.
Correct.
And it was essentially in the middle of the night too, right?
Yeah, I think it was close to midnight, yeah.
Yeah. In fact, one of her family members was actually in the bathroom, like using the restroom actively.
I think Ramon was, yes.
Yeah. Completely unexpected, right?
Yeah.
And every room was searched carefully.
Yes.
Every cabinet,
Yes.
under the mattress and the beds, everything, right?
Correct.
Trash cans.
Yeah.
And Stacy wasn't there, right?
She was in jail.
Right, she was already arrested at that point,
Yeah.
right? And her family's actually finding out that she's arrested through this process.
Yeah, I think so. I mean, I told them they were arrested. I don't know if they knew she was arrested before then, so.
They didn't tell you anything, like, yeah, I knew she was arrested on first-degree murder charges, and that's why you're
Yeah,
here.
yeah, they didn't mention anything like that.
Okay. And Mr. Dickerson's phone was never located in that residence.
No,
The Zales ring was never located in Miss Rodriguez's family residence.
no,
The debit card was never located in Miss Rodriguez's family residence.
no,
Not a single item belonging to Mr. Dickerson was located in her family residence.
no,
Throughout the investigation, as we've heard, there was also search warrants on Miss Rodriguez's Chevy Tahoe.
correct.
That was the 1999 Tahoe, correct?
Yeah,
And through the investigation, you and other officers learned that essentially Ms. Rodriguez kept a significant portion of her belongings in her Tahoe.
yeah, I learned that she was living on and off inside of the Tahoe, so there's a lot of belongings, correct.
Correct. And just like the residence, the search warrant was conducted under an element of surprise, right?
Well, yeah, I was at the police department,
Correct. Because as we've seen, we've seen her getting arrested, right?
correct.
In the parking lot.
Yeah,
And then we can all agree she was clearly surprised when you guys approached the vehicle and said you're under arrest, right?
yeah,
And then it was immediately sealed.
correct.
And so she didn't have any time to like hide any evidence in the search warrant hide any evidence in the Tahoe, correct?
Yeah, once she was arrested, she couldn't have gone back to the Tahoe.
Correct. And again, that Tahoe was carefully searched by skilled and trained officers.
Yes,
And you guys knew specifically what you were looking for.
correct.
Mr. Dickerson's phone was never located in the Tahoe.
No,
The Zales ring wasn't located in the Tahoe.
no,
The debit card wasn't located in the Tahoe.
no,
Not one single item connected to Mr. Dickerson was located in Ms. Rodriguez's Tahoe.
no,
Likewise, the Malibu was also seized, correct?
yes,
And you got a search warrant for that vehicle.
correct.
And again, officers searched the Malibu carefully, looking for these specific items that everyone knew were missing from Mr. Dickerson's house.
Correct.
And again, the phone wasn't located in the Malibu.
Correct.
The ring wasn't located in the Malibu.
Correct.
The debit card wasn't located in the Malibu.
Correct.
Not one item connected to Mr. Dickerson was located in the Malibu.
That's correct.
And again, that kind of makes sense because the phone or the Google location of Mr. Dickerson's phone did not remain near Ms. Rodriguez's family's residence.
That's correct.
As you testified yesterday, it was only there for approximately 6 minutes,
Correct.
and then it left.
Yes.
And it left by 6:19 in the morning.
Yes.
And Mr. Dickerson's phone traveled all the way down 11th Avenue in Greeley.
Correct.
And then at 6:37 in the morning, Mr. Dickerson's phone was located just south of 32nd Avenue and 11th Avenue.
It was, I think it was more closer to 31st Street and 11th Avenue.
31st Street?
Yeah, and 11th Avenue.
Do you recall writing in your police report that it was just south of 32nd Avenue and 11th Avenue?
It would be 32nd Street and 11th Avenue.
Okay.
If I wrote that wrong, then that's not correct. It would be right around 32nd Street and 11th Avenue. 32nd Avenue and 11th Avenue don't intersect.
Okay, so 32nd Street and 11th
Yes,
Avenue.
yeah.
Okay, thank you. And that was actually the very last location Mr. Dickerson's phone ever registered.
That's correct.
And that location is only 2 blocks away from the post office on 11th Avenue.
I think so. I think the post office is there. It's in Evans, so I'm not as familiar with Evans.
Okay,
but
would it help
It may
you-
be.
Would it help you to look at Google Maps?
Sure, yeah.
May I approach, Your Honor?
Yes, go ahead, please.
So just so the record is clear for, I'm showing you Google Maps, correct?
Yeah, you are.
And there is the 11th Avenue Postal Office, right?
Okay,
And there's that red dot right there,
okay.
right? And that is 11th Avenue and 32nd Street, right?
Yeah, 31st Street and then 32nd Street, they intersect with each other.
Correct. And
Yeah,
so there's approximately 2 blocks away from each other, correct?
approximate, yeah.
So the last known location that Mr. Dickerson's phone ever registered was only 2 blocks approximately away from that post office on 11th.
Yes,
And you know that Miss Varella's grandmother lives behind that same post office.
I knew she lived close to that area, yes.
Right. Specifically behind the post office is what Miss Varela described to you later during her proffer.
If she did, I don't remember that, but I don't discount that.
Okay. And you knew that Miss Varela would stay at her grandmother's house sometimes.
Yes,
And so the last known location of Mr. Dickerson's phone was only 2 blocks away from where Miss Varela would stay.
yeah, correct.
And you testified yesterday that you never got a search warrant for Miss Varela's location or potential residence because you knew that the phone was at Miss Rodriguez's house 20 minutes earlier for 6 minutes, right? And only registered that last time for 2 minutes near Miss Varela's residence.
No, it only registered 2 minutes near Hannah Varella's place from 5:57 a.m. to 5:59 a.m.
Okay,
I just know that it turned off approximately around that location.
okay. So we'll come back to Hannah's house, okay?
Perfect.
Despite knowing the last known location of Mr. Dickerson's phone ever was 2 blocks away from Miss Varela's grandmother where she would stay, you never obtained a search warrant for her grandmother's house.
Correct for numerous factors.
You never, and let's just make sure, when we're talking about search warrants, let's make sure the jury understands how this process works.
Yeah.
You don't get penalized for writing a search warrant to a court and it getting denied.
No, I don't get penalized, no.
It doesn't hurt to ask for a search warrant.
Well, there's a process that I have to go through to actually be able to bring a search warrant to a judge.
So, right, exactly. You have to write something.
Correct?
You write a document.
Yeah.
You bring it to a judge who's on call.
I don't just bring it to a judge.
What do you do?
I have to go through the district attorney's office.
Oh, they're the gatekeeper.
They are somebody that looks at something and says, have you met the basic elements to get a search warrant? And then I can bring it
So
to
you're
him.
relying on him, right, Mr. Parelia and Mr. McCormick, to say, can I get that search warrant for Miss Varella's house since I know Mr. Dickerson's phone last registered 2 blocks away from it?
I'm relying on not just them at the DA's office, everybody at the DA's office.
Right, they're the gatekeeper, you're saying.
They are somebody that says whether or not, yes, they are essentially whether or not it can go see a judge.
Right. And again, it doesn't cost you anything, right? You're not going to get in trouble if you bring a search warrant to a judge and they deny it.
No, and I can explain why I didn't go and get one at her house.
So let me just go over, we're going to get there, okay? I promise.
All right.
So
Okay.
the factors that you knew at the time, right, were the location that the phone was, the last
Yes.
location.
Yeah.
You knew it was missing in a homicide, right?
You're saying for the factors for Hosanna's family or for the 4540?
I'm talking about Miss Varela,
Okay, yes.
okay? So, or in general, either way, right?
Okay, yeah,
You knew the phone was missing.
correct.
You knew that it was a key piece of evidence.
Yes,
You knew the last known location of it.
yeah,
And you knew Miss Varela had a family, 2 family members in the vicinity.
one house, 2 family members.
Right.
Yeah.
Well, no, because Miss Hannah Varela lived in a different location, right?
Yeah, in a completely different location than what we're talking about, Hosanna's mother or grandmother's house.
Yes.
Yeah,
And you knew all of that information, right?
yeah.
And yet you never obtained a search warrant for Miss Varela's grandmother's house,
No, I did not.
even after the point of the proffer, right?
Yeah, and I can explain why that is too.
Why?
Because when I spoke to Hosanna Varela, she told me that certain evidence items were located at a trailer that was associated to Stacy. She told me that they did go to the grandmother's house that morning, but the items that were missing, she never indicated were at that residence. So at that time, I didn't have enough or believed I had enough to go to that residence. She indicated they were at a certain location.
So you just took Miss Varela's word for it, right?
In that instance, 7 months later, yes.
You didn't do anything to vet out that, to verify what Miss Varela was telling you in this instance, right?
Well, she didn't tell me there was any evidence items at her grandmother's house.
Of course not, right? She's telling you the opposite. She's telling you that Miss Rodriguez took these items to the trailer,
Yeah,
and then you went to the trailer, right?
yes.
And then you didn't find anything consistent with what she told you.
We didn't find the items, no.
There was nothing consistent with a massive bonfire that burned all this evidence, right?
We found a stationary or outside fire pit, but we didn't find a location where items were buried.
You didn't find any ash,
Not in the ground, no.
right? You found nothing at that trailer to support what Miss Varela told you about the items of evidence being burned there.
We didn't find any of the items, no.
And so even at that point, you're not like, maybe we should take an additional step and verify what Miss Rodriguez is telling us and get a search warrant for her grandmother's house.
So the same factors of why I did not get a search warrant at Hosanna's grandmother's house that first on November 11th still play into why I still didn't go back and do it that day.
Because he told you not to.
He didn't tell me not to.
Okay. But he's the gatekeeper, right?
He is somebody that I would consult about whether or not getting a search warrant.
Because also, if you got a search warrant and there was something there, there was a phone there,
Yeah.
that certainly would have made things really messy when you guys, after you've done the proffer, right?
I can tell you this. If I would have found evidence that proved Hosanna was a liar, I would gladly welcome it. Absolutely.
Right, but you didn't bother to do it. You didn't bother to vet her story out.
Again, I can explain why I didn't get the search warrant at Hosanna's house that day, and then that plays into my decision later on whether or not I get a search warrant. Those factors still come into play.
Of course they do, but
Yes.
it doesn't hurt, right? There's no negative aspect other than it discredits Hosanna's story.
I have to have articulable facts that the items I'm looking for are in that place.
Such as it being 2 blocks away, right? From the
mere-
last known location of a dead guy's phone.
A mere location is not enough in that circumstance.
But you certainly got it at Miss
I can explain exactly what all the other factors that played into it too.
because you knew about the car change, right?
Not just the car change. So the car, the Tahoe, was registered to 4540 First Street Road. That's Stacy's residence. The Malibu was registered to 4540 First Street Road. That's Miguel's car. I also knew that her listed address was 4540 First Street Road. Then on November 11th, the first place we see Stacy and Hosanna together when we're doing surveillance is at that location. They're back at that house on the day that we arrest them.
And I'm glad you bring that up because you also never conducted surveillance at Miss Varela's grandmother's house.
We looked at the places that I knew that they could potentially be. I don't know if I gave locations to officers to go and look. I don't know if they went and looked at other locations.
Sir, you're the lead detective in a homicide.
Yeah, I am,
The buck
yes.
stops with you. You direct people where to go, right?
I do help and guide, and I set out a plan, but it's a team effort.
It's a team effort. And not one member of the Greeley Police Department was like, let's conduct surveillance at the other person's house.
So if you're indicating that before June 8th, before I knew Hosanna's proffer, before I knew anything she said in the house, that I had a bias towards Stacy in my initial investigation, that's false. I went to the...
Sir, I'm just answering my question. Just answer my question.
Okay.
The Greeley Police Department never conducted surveillance at Hosanna Varela's family member's house.
We conducted surveillance at the locations we believe Stacy and Hosanna would be at. And those all...
Mr. Burrows, it's really important that you answer the questions that are
Okay.
posed to you.
I'm sorry.
So we can get through this.
Yeah, I'm sorry. No, we didn't.
Thank you.
Okay.
Likewise, surveillance was never conducted at Miss Rodriguez's sister Hannah Varela's house,
No.
even though you knew, again, that Mr. Dickerson's phone at one point around 5 something in the morning was near her house.
That's correct. We didn't conduct surveillance there.
And just to clarify, during this initial time before Stacy and Hosanna were arrested, you knew that Hosanna had family members at 3221 11th Avenue.
Before we arrested her?
Yes.
Yeah, I knew there was family there.
Yeah, just to make sure we're all clear about that.
Yeah.
Because you actually wrote like a really nice summary about the evidence that you had at this point. And you wrote in that, quote, "In further research of Hosanna, I found an Evans Police Department case involving Hosanna at 3221 11th Avenue."
Correct, yeah.
And then 2 sentences later in that same summary, you write, quote, "Christopher's phone was last registered at a location near 3200th block of 11th Avenue."
Correct.
And then just so we're clear, Hannah's address is on 29th Street, correct?
Correct.
So we're talking about 32nd Street and 11th in one location, and then just 29th Street in Hannah's location.
Yeah, it's on the west side of Greeley.
Right. And Mr. Dickerson's phone was at the 29th Street location at 5:57 in the morning, October 3rd.
Yes.
And just so we're clear, surveillance was also never conducted at Hannah's location either.
No.
Surveillance was also not conducted at Javi's residence.
No.
And so then the arrest happens,
Correct.
correct? And Mr. McCormick went through a long list of things that Ms. Varela told you about during the June 8th proffer, right?
Correct.
Yesterday.
Yeah.
And went through this whole thing about how it's consistent with what we know,
Yeah.
right? And I just want to kind of go through those things. Grab my computer real quick.
Okay.
One of them was that there was a dog, right?
Correct.
And that was consistent with the video Mr. McCormick pointed out.
Yeah.
That's also consistent with her just being there, right?
Yeah, correct.
Right. And then there's the sound system being in the car from the video. You could see that too, right?
Yeah.
Again, that's consistent with her being there.
It is consistent with her being there.
Then there's the evidence that she went into the back seat, and that's consistent with her being there,
Correct.
right? And then the Tahoe switch, right?
Correct.
Drinking Budweiser in the house, right?
Correct.
All of that is consistent with her being there,
Correct, yes.
which if she had up to E65, and just so the jury knows, by E65, these two are already arrested,
Correct. Yes, I think so.
right? Because Detective Hunziker's report is supplement 63, right? And
Okay. Then,
That-
yeah, then yes, they would have been arrested.
because he was the one that approached the car.
Yeah.
And so by the time of the arrest, you knew all of this information, such as the information from the video surveillance, right?
Yeah.
You knew about them coming and going in the middle of the night
Correct.
because that was from the video surveillance.
Yeah.
You knew about the Google location records, right?
Yes.
Because again, that's how you essentially tracked these people down.
Correct.
The Cosmic Mart, right?
Yeah, I knew about them. They weren't in until sub 76.
That's not my question.
Okay, I knew about them, yes.
All of these things that you mentioned with Mr. McCormick are things that helped you track these two people down.
Correct.
And as we just talked about, all of that was there by sub 65 because it all helped you get to the point of their arrest.
Correct.
The only thing that wasn't there was the information about the weapon in the neck from the coroner, right?
Correct.
You said yesterday it was supplement 81.
Correct.
But again, she was there, right?
Correct, she was.
We also saw in prosecution's exhibit P88, the picture of the still shot of the interaction between Mr. Dickerson and the silver Malibu.
Sorry. Yeah,
Do
yeah.
you need a minute?
No, I'm fine.
Okay.
Did I answer? I said yes.
Yes,
Okay,
I appreciate
all right.
that. We saw that picture, right?
Yeah.
And as you can see in that picture, Mr. Dickerson is leaning into and talking through the passenger side, right?
You see him like turning his head towards it. I don't know if he's leaning. He's still standing erect, but
Okay.
he's turned towards it, yes.
He's on the passenger side.
Correct, yeah.
He's clearly having interaction with the passenger side.
Correct.
And Miss Varela was on the passenger side, right?
Yes, she was. I believe so.
So when she told this jury that she didn't talk to Mr. Dickerson and that Stacy did all the talking, that's not consistent with the picture.
Well, I can't
video.
I can't say who was talking inside of the car. I can just look at a picture and say, yes, he's looking at a window and the window appears to be down.
Right.
And Hosanna, yes, is in the passenger seat, but I don't know who said what
That's
in
fair.
there.
That's
Yeah.
fair. But Mr. Dickerson didn't go to the driver's side, right?
No.
And the passenger side was rolled down.
Yes.
And so by the time the two women are arrested, ruled a homicide.
Correct.
You knew that Mr. Dickerson had died not from the fire.
Correct.
And you had these two women in custody because you knew they were there.
Correct.
But at that juncture, you had absolutely no evidence of what happened inside the house that night.
And no evidence of what each person did inside.
Correct.
I knew what happened to Christopher and I knew the fire.
Right.
But what the people's role, no.
You had no idea the play-by-play of what happened inside those four walls.
No, I did not.
And likewise, you had no idea of what happened those few minutes after Mr. Dickerson's death.
No, I did not.
And so the months go on. They're arrested November 11th. The months go on. You're doing things like pulling jail phone calls, right?
Correct.
Jail letters.
Correct.
There's no evidence to help you out, right?
As far as like what each person's role was?
Yes, that's
yeah.
better.
Yeah, no.
Right. And you carefully reviewed those letters and phone calls, right?
Yes.
And that didn't help further figure out what happened inside Mr. Dickerson's house that night.
No.
And the optics weren't really the best, right? So you had an almost 36-year-old male bringing two strange girls back to his house at 2 and 3 o'clock in the morning, right?
Are you asking me if like I think those optics are bad?
No, I'll take back the optics. I'm
Okay.
just telling you what you had, right?
Yes, that's what I had.
Right. 2 or 3 o'clock in the morning, one of those girls was underage, under
19?
drinking age,
Yeah.
right? So not even old enough to drink,
Yeah.
right? And she's just a year older than the legal age, period, right?
You mean Hosanna?
Stacy,
Oh, Stacy. Yes, I see what you're saying now. Yeah.
right? And you knew that both of these girls were 5'4" tall.
Yes.
You knew that Mr. Dickerson was 6'2" tall.
Correct.
And you also knew that Mr. Dickerson was not, and I want to be respectful when I'm saying this, he was not as overweight as the females, right?
Correct.
And you also knew at this point that there had absolutely no connection between Miss Rodriguez and Miss Varela and Mr. Dickerson.
Correct. They didn't.
And so then comes June of 2022, and you've pretty much exhausted all avenues of criminal investigation. Is that fair to say?
Yeah.
In terms of figuring out what happened in the house.
Yeah. Yes.
Yeah. There's no other witnesses.
Correct.
The house is burnt, so there's no DNA inside the house.
Yeah.
There's no more video surveillance to get.
No.
You even do things like getting the Google, I think they're called Google fences, but going to all the neighbors and asking them if they're comfortable with you guys getting who attached to their Wi-Fi.
Correct.
The court processes had started, right?
Yeah. Yes.
Because the women had been arrested.
Yeah, they had by then.
And then there's still no evidence of what happened in this house.
Of what each person did know.
That's a problem, huh?
I don't think it's a problem.
Okay, but is a problem enough for the district attorney's office to arrange a proffer with Ms. Varela, right?
I can't speak to why the district attorney arranged that. I can just say I was confident in my investigation.
Okay, but a 7.5-hour proffer was done, right?
Yes.
And during that proffer, we've kind of talked about this a little bit, so I don't want to go too into it.
Okay.
But one of the very first things you tell Ms. Varela is like, I'm just going to sit here and let you tell me your story.
Correct.
And that was like a 43-minute narration, right?
Correct.
And she just went for it, right?
Yeah.
And at no point during that initial 43-minute narration did she say, you know what, Detective Burrows, I can tell you the exact moment Ms. Rodriguez told me she was planning on killing him.
No, not during that time, no.
No. She was never like, hey, Mr. Burrows, or Detective Burrows at the time, I know I'm here to tell you all of the information about the night of this killing, and I'm just gonna, or let me take it back. At no point is she like, I know I'm here to tell you everything, and I'm doing through this narration. And at no point is she like, by the way, I asked Ms. Rodriguez at what point she decided to kill Mr. Dickerson.
During that first 43 minutes, no.
No, it wasn't until like 3 hours later, after she met with Miss Lily for 30 minutes, that she tells you that information.
I don't know if it was directly after they met, but I know it was later on when I was asking her questions that she brought it up.
Right, it was after the point she met with Miss Lily. You had stepped out of the room and given her and Miss Lily an opportunity to talk.
Okay, then that's fair.
Okay, and it was also really impromptu, right? So let me rephrase that. When she disclosed that key piece of information
Sure.
of when the intent to kill Mr. Dickerson was formed,
Yeah.
it was not responsive to anything you were asking.
No, I was talking about something, and then she said, hey, I remember something, and then brought it up.
Yeah, you were asking her about how many times Mr. Dickerson had slapped her rear end.
I think that's correct, yeah.
And you heard her tell this jury that it was just a minor event, happened 1 or 2 times, and she thought maybe it was just, kind of by accident. But she told you something different on June 8th, right?
I remember when we talked about it, she mentioned that it made her uncomfortable, but I don't remember like the exact words that were said to that.
Okay, wait, refresh your memory. Let me ask you this.
Okay.
Do you recall her telling you that Mr. Dickerson slapped her rear end or grabbed her rear end 4 to 5 times?
I think so, yes.
Do you remember her telling you during your proffer that Mr. Dickerson did it every time she stood up?
I think so, yeah.
Do you remember her telling you that it made her very uncomfortable
Yes.
and that she just wanted to leave?
Yeah, she said it. I don't know if it was in direct relation to that. She said at points during the night she wanted to leave, and then there's points where she was comfortable, like when they're in the car.
Do you remember her telling you that before Mr. Dickerson got the phone calls to go to pick up his friend, she wanted to leave?
Yes.
Like she didn't want to be there anymore. She was that uncomfortable.
Yes.
Also, during this initial 43-minute narration that she gives you, she doesn't tell you anything about Miss Rodriguez licking the blood and saying it tastes dirty.
No, not at that time.
She doesn't tell you anything during the initial 43 minutes about Miss Rodriguez being a serial killer who's killed 3 to 4 other people.
No.
And she also certainly does not tell you at all during the proffer anything about Miss Rodriguez burning other bodies or telling her she's burnt other bodies.
No, not during the proffer, no.
No, she just said that for the first time during this trial.
That she didn't relay that to me.
Right. And Mr. Pralia, you saw him, was asking Miss Varela some questions about the gang ties, right?
Yeah.
When she was testifying. And he pointed out that at one point Miss Varela described to you talking on the phone with someone she didn't know who it was, right?
Miss Varela was talking to somebody?
Miss Rodriguez was talking on the phone.
Are you saying, okay, can you ask again?
Sure.
Okay.
So Ms. Varela testified that she had told you during the proffer,
Yeah.
overhearing Ms. Rodriguez on the phone, and she didn't know who she was talking to, right?
I
Remember
don't,
that part?
I don't know if she said that portion during the proffer. I mean, I think she talked about the gang ties, but I don't know if she spoke about a phone call specifically.
So your testimony today is that Ms. Varela told you the word gang ties or gang during the proffer.
I think she did. If I remember correctly, I thought she mentioned something about her family having some sort of gang ties, and she didn't know, or she was associated to people, and she thought they might have been from California.
And while I'm pulling up a transcript for that, as a member of the Greeley Police Department, you have a really nifty program called the Gang Unit, right?
They are still around and kind of barely. They were at that time, yes.
Yeah, they have like all their cool gear, their jackets that say Gang Unit,
I
right?
don't think it's that cool.
Okay, that's fair. I mean, neither do I, but still, right? I mean, they're a specialized unit, right?
Yes.
And they track gang members in this community.
Yes.
And they've been doing it for probably, a couple decades now? Is that fair to say?
Yeah, I think it was the early 2000s it was formed. Like, I think 2004, 2005, we had some bad problems.
Right. And so at no point did you have any information that Ms. Rodriguez was affiliated with any gang.
Yeah, I can do that search myself in our system, and I didn't see that.
So this is not true, right?
Yeah, she's not tracked, is all I can say.
But there was nothing also that would suggest that she had any gang ties, right?
Yeah, we didn't have any gang contact forms, or she wasn't tracked as a gang member.
Well, also, you've gone through her residence, her cars, right?
Yeah.
Her cell phone records,
Yeah.
right? Her Facebook records, right?
Yeah.
Right?
Yes.
And not one, piece of evidence that would suggest that she has any kind of gang ties.
No, I didn't see anything obvious.
No. And you know that gang members talk a very specific way, right?
I mean, it depends.
Okay. They use some sort of coded language often.
It honestly depends per gang, per click, and it changes. So it depends specifically on that gang. But they do, I can say this, they do have specific language associated with their specific gang.
Like numbers, signs, colors, right?
Yeah.
And nothing that corroborates what Ms. Varela tells you that she's in a gang.
I didn't see any evidence she was in a gang.
Nothing in the entire resource of the Greeley Police Department in the 3.5 years you've been investigating it suggests that that woman is in a gang.
I didn't see any evidence, no.
Okay. Sir, I'm going to show you a transcript of the proffer interview.
Okay.
And the really nice thing about transcripts in Microsoft Word is you can quickly do a Control F and search for a keyword, right?
Sure, yeah.
Okay. And so would it help you to recall if Ms. Varela ever mentioned the word gang to you in this proffer?
Sure.
Same things you can cross on it. Can I approach her?
Yes, please.
Okay, so this is the entire proffer interview, right? Do you want this on the record? Yes, thank you. Sorry, I pulled this. So this is the proffer interview, okay? And actually, we can even go to the video so you can make sure it's the correct one, okay? And again, it was a 7.5 hour approximate proffer interview.
A very long interview.
Yes. So it will do this. You see I'm scrolling all the way down to 7 hours and 28 minutes and 7 seconds, right?
On the Word document, yes.
Yes. And then also I'm showing you, is that the room?
Yeah.
Okay. I'm not going to play the sound. Is that Miss Varela?
Yes.
Is that you?
Yeah.
Is that Mr. Perelia sitting there with her too?
It's his back of his head. I assume it is. I can't say for sure.
But he was the one sitting next to you, to the left of you during that proffer interview, right?
At the beginning, and then he left.
Yeah.
Could you put the mic between the two of you?
Sorry.
Sorry.
Okay, I'm searching gang. Does anything pop up there?
I don't see anything.
Okay. Now I'm going to go back to the Word document. Search, Control F, gang.
Okay. Here's what I can say to
Judge,
that.
I'm going to object at this point. That's not a verified transcript. She hasn't had an opportunity to show.
Can the parties approach?
Clips of the video, I don't see the actual 7-hour video.
Do you want to watch the entire 7-hour video right now?
All I'm saying is I believe she said the word gang. I would feel more comfortable seeing a clip that we could say whether or not she said gang.
Can you direct me to a place in the 7-hour interview?
Well, I don't remember exactly when she said it. All I remember, and I'm not saying I can't be wrong at all. I'm not saying that. I'm just telling you what I remember is that I thought she said something about a gang and then her family being from California.
So if I Control F the word family and you look at every single time the word family was mentioned in the 7-hour proffer, would that help you?
I can't. I mean, it's a 7-hour interview. I mean, we can try it with your program. I'm not saying I'm not trusting it. I'm just saying it's a long interview, and I don't know exactly when she said it. And again, I could be wrong. I could be wrong.
Right. Because if the word gang was not mentioned, that would, again, discredit Ms. Varela's story, right?
As far as what?
Her telling you that Ms. Rodriguez was in a gang.
You mean when she testified?
When she met with you right before this trial, right?
Oh, you're saying on that day?
Yeah. And also when she testified to this jury.
Would it discredit all of her story, or just saying that
I'm
instance
just
right
saying,
there?
I mean, could be both, right?
Yeah. All I can say is
Yeah.
if I thought I remembered the word gang, I could be wrong. And she then told us when we met with her that she was associated to a gang.
So in addition to the video, because I don't think anyone wants me to sit here and have you listen to a 7.5-hour interview.
No.
You wrote multiple supplemental reports, right?
Yeah.
And clearly, if Ms. Varela told you that your suspect in a homicide case was part of a gang, you would have included that in your supplemental report.
Not necessarily, no.
No?
No.
No.
Well, because when she told me that during the proffer, I didn't exactly do a transcript after that. And I would include that if it was relevant, but I didn't see anything that was relevant to the case at hand of Mr. Dickerson's death.
But again, if she had told you that during the proffer,
Yeah.
and she's telling you as a reason why she was afraid of Ms. Rodriguez, and so afraid of Ms. Rodriguez that she
Yeah.
didn't come forward, that would have been in here because that is relevant. Just like that's the whole reason why this jury heard about it.
So what I would have done is I would have went and confirmed if she was in a gang. And if I found that to be true, then I would have included it. But I didn't find anything that said she was in a gang.
So you're now testifying you did look into whether she was in a gang.
Yeah, I looked into Stacy well before Hosanna even told me about the gang thing. I did a thorough search on her. I went through all her police reports. I read every police contact that she had. I mean, I did a thorough search on Stacy, and I didn't find any evidence of her being in a gang at that time.
Okay. But again, the entire significance of Ms. Varela telling you, or this jury,
Yeah.
that Ms. Rodriguez was in a gang, the entire purpose of it would have been why she was afraid of her and why she was afraid of coming forward.
I don't know if I can't speak to if Hosanna was directly afraid of that. I can just tell you what I believe I heard in the proffer and then what I researched.
And again, that was never included in any supplemental report you wrote.
Yeah, I would only include it if she was actually in a gang.
Not that Ms. Varela believed she was in a gang?
No, I mean, there's a lot of things that I looked into that Ms. Varela said that I didn't include in a supplemental report.
And you know what, I'm not going to make you listen to a 7.5-hour
Okay.
proffer interview. And I would hope that these people right here get up and play that proffer interview and says, by the way, detective, me being Miss Varela, she's in a gang, okay? So
Okay.
we'll see if that happens, okay?
Okay, and I could be wrong.
And the point of this is, as you're going through this proffer with Miss Varela, she's telling you some pretty extreme things that you do document, that you do remember, right?
As far as what?
So Miss Rodriguez being a serial killer,
Yes,
she's telling you she believes Miss Rodriguez has killed 3 to 4 other people.
yes,
And again, as you just testified, you looked into Miss Rodriguez extensively.
yeah.
No evidence of that.
She wasn't associated to another homicide, no, that I could see.
You don't know if the Greeley area or Colorado has this string of murders that have just have gone unknown, right?
Not that I know. Well, I'm sure there's murders that have gone unknown,
Correct.
but I don't know.
Right.
That's hard to say, I would say.
But nothing you ever found corroborates any of this, right?
Nothing that I found with Stacy, no.
Right. And then she tells you things that are even more extreme, right?
Okay,
Like this fact of Miss Rodriguez is licking the blood, saying it tastes dirty.
yeah.
And you weren't saying, okay, ma'am, now you're telling me she's a serial killer. Now you're telling me she's licking blood. You never like pushed back with her during this proffer interview. You're not like, man, this sounds a bit much.
Well, I think to put in context how I do interviews and how I interpret information, I can explain a little bit of that, of why I take that information and what I do with it.
Well, you testified already. You look into it, right?
Well, and there's also a process I go internally when somebody's telling me something.
And Mr. Burrows, again, you got to answer the question.
Okay, can you repeat it again? I'm sorry.
Sure. The point is Miss Varela is telling you some pretty extreme things during this proffer, and you never push back on her. You never say, ma'am, this sounds pretty extreme.
No, during that time, no.
And then at one point during the proffer, again, speaking in the context of some red flags in Hosanna's story, you ask Hosanna, do you know if Stacy took anything from the house?
Yeah,
Right? And that was at hour 4, minute 2, and 26 seconds of the proffer interview.
okay.
I'm not expecting you, sir, to know that. Would it help you to, because I don't want you to testify just to agree with me, okay?
And I don't want to do that either.
Right, so would it help you to look at that portion of your proffer?
If you want to show it to me, you can.
Okay.
Okay.
Just for the record, this is June 8th, 2022, the proffer interview. The timestamp is 12:20:56, and it's 4 hours and 2 minutes and 26 seconds into the proffer interview. May I approach?
Yes, go ahead. And you can approach freely for this purpose.
I hand you some 19.
Perfect. Awesome. All right.
I really don't want to blow out your ears. so
Okay,
can you just-
I'll take them off for a second, and then I'll put them back on. Okay.
Not sure.
Yeah. It skipped ahead. Yeah.
4:2:26.
Yeah, no, I can see. I'm good. I'm good with this.
You good?
Well, If you're asking me what she said she took, it like you touched it and skipped
No, I'm just
ahead.
asking you the time that you asked her the question.
Oh, okay, yeah, okay.
Do you remember your question now?
Yeah, when I asked her the question, yeah, the time.
So, 4 hours, 2 minutes, and 26 seconds, right?
Yeah.
Into the proffer, you say, did you know if she took anything from the house?
Yeah,
Before that, Hosanna is never like, hey, by the way, this is specifically what I know Ms. Rodriguez took from the house.
I don't remember if she did or not before that. I just know I asked that question at that time.
Because you wouldn't have to ask that question if you already knew that.
Yeah, probably.
And that's when Hosanna, of course, claims that Ms. Rodriguez was the one who took all of these missing items from Mr. Dickerson's house, right?
Correct.
There's the debit card, right?
Yeah.
And just to be clear, she told you debit card, right?
I believe so, yeah.
She never mentioned the wallet,
No.
because you know that not to be true,
Yeah, because the wallet was in the car.
right? So in that instance, Ms. Rodriguez's testimony, as she told this jury, was not corroborated by the physical evidence, right?
Yeah, she said she thought he took a wallet.
Right. And it's hard to keep your stories the same from debit card to wallet almost 5 years or 3 years later, right?
I don't know if I can speculate on that.
And I want to talk about the debit card, okay?
Okay.
Because that's what Ms. Varela told you Ms. Rodriguez took during the proffer,
Yeah,
right? When she's telling you, officer, I'm telling you all the truth, and I know the importance of telling you the truth, right?
correct.
The debit card, you knew was missing, right?
Yeah, we believe so, yes.
You also wrote in one of your supplemental reports that there's also a likely possibility that it could have been burned with Mr. Dickerson's body.
That's correct, yeah.
If he had it in his pocket from going out that evening, that could explain the missing debit card.
Yes.
And as part of your investigation in this case, you and other members of the Greeley Police Department looked into Mr. Dickerson's finances.
Yeah,
Because obviously if his debit card's missing and someone went through all of this trouble to kill him and rob him, presumably they're going to steal from him too, right?
I would believe so, yes.
That's at least why you pulled things like his Farmers Bank records,
Correct,
his Sam's Club credit card,
correct.
and there was no fraudulent or purchases on the Sam's credit card that you knew about, right?
No.
And when you got the Farmers Bank records, you found out that he had $43,293.58 in his account.
He did, yeah.
Not a penny was ever taken.
Not that I know of, no.
Not a single dime, right?
Yeah, not that I know of.
And that's significant if you believe Ms. Varela's story, which is that Ms. Rodriguez was pumping him full of alcohol to do this killing, to then rummage through his stuff and steal his debit card, right?
I guess, what do you mean by significant?
That nothing was ever taken, right? You go through all this trouble
Okay.
to poison someone with vodka, to kill them, to burn their house down, to rummage through their things, and not a penny was taken, right?
From that account?
From anything with you never found a single dime taken from Mr. Dickerson.
Monetarily, no.
And then there's the gift card. Okay.
Yeah.
That was something that Ms. Varela told you about the proffer, right?
Yeah,
And because you're the lead detective in this case, you were familiar with the items that were found in evidence, right?
yeah,
It's your job, right? And of course, when you're hearing this information from Ms. Varela in June, you can't go back to that Walmart and pull the security video because it's not going to be there,
yeah.
right?
It's not going to be there.
It's not going to be there, of course not. But you know, inside of Mr. Dickerson's wallet was a Walmart gift card, right?
Yeah,
You know, there was a Walmart gift card. You know, there was a $100 Master gift card.
yeah,
You know, there was not one but 2 gift cards to Sprouts grocery store,
I knew there was gift cards in there. I don't know every single gift card that was in there.
a Fuzzy's taco shop gift card,
Sure,
a JCPenney, if there is even a JCPenney anymore.
Sure.
A gift card to King Soopers.
sure.
There was 8 gift cards,
Okay,
right?
yeah.
But yeah, Ms. Rodriguez just took this one.
The one that was
You can't speculate, right?
No, I can't. I don't know. The wallet was in the car
The car that she was in too, right?
earlier in the night. Yeah.
And the car in the house that she's rummaging through to steal all this stuff from him, right?
I don't know where she rummaged through it exactly inside of the house, other than the bedroom.
Then there's also Miss Varela's testimony about Miss Rodriguez, of course, forcing her to turn on Mr. Dickerson's cell phone at a later time. Remember
Correct.
that? And she told this jury a pretty dramatic account of looking through his phone and looking at pictures of his dog and his girlfriend and making her sad, right?
Correct.
But you know that Mr. Dickerson's phone was never turned back on.
I don't know that for sure.
But you know that Mr. Alan Dickerson gave you Verizon cell phone bills up until including November of 2021.
Yes, I think so.
So, and the girls weren't arrested until November 11th, right?
Yeah.
And so you also got Mr. Dickerson's Verizon phone records,
Yeah.
right? And as we've seen, when a phone is on, there's some sort of documentation of it, right?
No, because when a phone is on, the documentation happens when there's like data pulled or if there's a phone call made, from what I understand.
No, because as we've seen, right, from Miss Varela's phone,
Yeah.
pinging to the location at UNC,
Yeah.
right? Phones are just routinely searching for towers.
No, that's when it's pulling specific data. It actually tells you on there the data that's being pulled. On those records, in the columns, it says how many bytes are being pulled.
Sir, do you have a cell phone?
Yes.
When you open your cell phone and you turn it
Mm-hmm.
on, what is the very first thing it does? It connects to the network, correct?
Yeah, but what I'm saying is what I see in the records is only when there's a phone call or data session made.
Right. So if the girls were going through his phone and opening any kind of app, or as we've seen from the Google locations, right?
Yeah.
So we know for a fact when Mr. Dickerson's phone is on, right? We know that. You have Google, at least Google locations, right?
Yeah, I don't know for a fact what that phone would have done at that time. I can only speak to what the phone did at the time when Christopher had it and then when Stacy and Hosanna had it.
But you would agree. And you know, because there was actually a phone call you had with Mr. Alan Dickerson sometime in November where he's like, this is really odd. I'm looking at Christopher's Google records and it's showing by my house. Remember that?
Yeah.
And he didn't realize the fact that when he logged into like Christopher's email on Google, just by merely doing that, it pinged his location, right?
Yeah.
And so Alan Dickerson was like, this is really weird. What's going on? I know the phone's missing, right?
Yeah, I mean, but that's directly tied to his phone.
That's not my question, okay?
Yes, that
Mr.
happened.
Dickerson called you and you told him, I've been monitoring Mr. Dickerson's Google locations, and you explained to him why it's showing that the phone is active when it's really not.
I think I can clear this up. During the time, I don't know about the connectivity to the towers. I can say I didn't see another Google location during that time.
Right, and we know when Mr. Dickerson's phone was on October 3rd, the locations were tracking, right?
Yeah. Yes, they were.
And you have no evidence ever that you found in 3 years from Google, from Verizon records, from anything that Mr. Dickerson's phone was ever turned back on.
Again, I can't, the cell phone records I think are separate. As far as the Google location, I can say, yeah, I didn't see another location. I didn't see another location register.
So yet another piece of physical evidence that shows or discredits Miss Varela's story.
I wouldn't say it necessarily discredits her story, no.
Or certainly in that aspect of it, right? And her testimony.
Again, the factors that I laid out, there could be reasonable explanations why that didn't happen.
Then there's also even more cell phone evidence that contradicts what Hosanna told you. So Hosanna during the proffer tells you that during those first few hours at Mr. Dickerson's house in the early morning of October 3rd, that she took a picture with her phone.
Yeah.
Yeah. She described being so uncomfortable that she took a picture of her phone that you could only see her legs, Mr. Dickerson's legs, his dog, and Stacy's hand.
Correct, I remember that.
And she told you specifically, actually, she mentioned this picture multiple times during her proffer interview with you back on June 8th, 2022.
Correct, yeah.
And at that juncture, in June of 2022, you had already...
To the cloud, which is separate from your phone.
Right. So it literally takes what's on your phone and puts it into the space.
Yeah, it depends. It really depends on what parameters you set, but you could, in theory, have everything go to your phone or just limited information go to the cloud.
Correct. And so that's why you do, for that very reason, right?
Yes.
You do a warrant for the phone, but then also the cloud.
Yeah, correct.
Just to make sure no one's hiding anything, right?
Correct, and Google as well, too, works the same way.
Right, I appreciate that. And when Ms. Farrell is telling you during her proffer about this picture, you knew that that picture was never found in her cell, on your phone during the cell breakdown?
Yeah, I didn't, so that's something that I looked back on the back end to see if the picture was there. So at the time she's telling me about the picture, I had gone through the pictures, but that didn't ring a bell to me, so then I went back and looked at it later.
Right, and it would have rang a bell because you knew Mr. Dickerson had this dog, Juna, right?
Yeah, yeah.
You knew that he was white, or she, I don't know if it's a he or she.
Yeah, the dog was white.
Dog is white,
Yeah.
right? And you knew, you were carefully looking through all of these phone records in the Celebrate to get any evidence from October 2nd or 3rd, right?
Yeah.
Or anything. Certainly seeing the dog would have jumped out at you, right?
Yeah, I mean, I didn't see a face of a white dog. I don't remember seeing that picture beforehand.
And Celebrate's a really cool program because you can click a button at the top that really easily distills the date of images, right?
If the image is captured, like separate from a screenshot, if the image is captured, it usually, for the most part, will give like a created date or a modified date.
Right. And again, by the time you did the proffer on June 8th, 2022, you never, after carefully going through everything, you never saw this picture.
Before that date, no, I don't remember seeing it.
And so you're hearing, and also likewise in the cloud records too.
Yeah.
And so you're hearing Ms. Varela say, or Ms. Varela tell you about this picture she took, and you're like, that wasn't in anything I saw, right?
No, because I mean, at that time, I mean, I'm going through so much. Like I said, I didn't specifically look for that picture. As I'm looking through pictures, I was mostly looking for more text messages at that point as I'm going through, because it takes a long time to go through phones. It takes a long time to search through everything. It wasn't until she said that I actually went back and specifically looked for that picture.
And I appreciate that, but we're also talking 8 months into this investigation, and surely you would have seen a picture of a dog, Mr. Dickerson's dog.
I can try to explain that. I can just say that it takes a while, and then I also have, I mean, I can explain what else was going on around that time with the investigation and the other things that I was doing too, if I can.
That's not my question.
Okay. I don't remember noticing that picture when I went through it beforehand, and then I went back to try to find it again after.
And what's odd about all this about the picture is it wasn't until 5 hours and 50 minutes into the proffer, she tells you for the very first time, after mentioning this picture multiple times earlier, that she actually deleted that picture.
Yeah, she said she deleted it.
Yeah. And she had just completely neglected every time she mentions this picture, the 5 hours and 50 minutes earlier. Oh, by the way, detective, I also deleted that picture
And she told me she deleted it.
later, right? And when she's telling you and describing to you during the proffer that she deleted it, she's actually kind of like stuttering through that process, right?
I don't remember if she was stuttering or not.
Would it refresh your recollection to review that part of the
Sure, yeah.
proffer? And let me be clear also, her telling you that she deleted it came after you asked her, quote, did you delete any of the things that were from that night. Any of the text messages or the picture you took inside the house, right?
Sure, that sounds about right.
She didn't volunteer it, right?
Again, if you're saying that's what I said on there, I don't discount you. I'm not saying it. That's not true.
So I'm going to show you part of the proffer, the timestamp, June 8th, 2022, and it's going to be at, timestamp on the video is 14:10:59. It's going to be 5 hours and 5 hours and 52 minutes and 25 seconds into the proffer itself.
Okay.
May I approach?
Yes, go ahead.
Was that, sorry. Was that volume okay?
Yeah, it was okay. Yeah.
Do you remember your question?
Yeah.
So again, you had to ask her, did you delete this picture?
Yeah.
Because you knew it didn't exist, right?
Again, I don't remember specifically looking for that picture. That information I learned then, that's when I went back to look and see that it wasn't in the phone.
And then after you ask Miss Varela, did you delete this picture? She goes, and then she tells you I deleted it, right?
Yeah, and then she goes into what took place.
So there was that initial kind of stutter response.
Sure, yeah.
And then she comes up with this story for the first time that you're hearing about how she told Stacy that she took this picture and that Stacy was livid, and that was why she deleted it.
I think it was something to that effect, yeah.
And Hosanna claimed that she deleted the picture from both her phone, right?
Yeah.
And then she described to you somehow essentially breaking into her sister's phone at a different location and deleting it off her phone too.
Yeah.
So Hosanna is telling you that she was able to essentially distract her sister Hannah, steal her phone, go into the phone and delete it, right?
I don't know if she said she was distracting her or she just asked for her phone and then Hannah gave it to her or something like that.
Yeah. And that more significantly, Hosanna claimed that she was able to delete the picture. And she said, quote, my sister doesn't even know about it.
I think she said something like that, yeah. At least the deleting the picture part.
Right. She said, quote, and I was like, yeah, sorry, my sister doesn't even know about it because I had deleted that off my sister's phone. And to this day, she doesn't know anything about it.
Okay, yeah.
But that was inconsistent with 4 hours earlier in the proffer. Hosanna told you that her sister definitely did know about the text message, right?
The way that I took that was that she knew about the text message,
Sir,
but she...
again,
Okay, yes.
thank you. And the reason why you knew she knew about it was because at 1 hour and 31 minutes and 40 seconds into the proffer interview, Miss Varela tells you that she sends this message to her sister, and her sister actually responded to the message.
Yeah.
And her sister responded immediately saying, oh my gosh, be careful.
Yeah, according to Hosanna, yeah.
So that means she saw the picture and saw the situation of her being at this random guy's house in the middle of the night, and her sister was cognizant enough to be like, oh my God, be careful.
Yeah.
And regardless, and you were here, Miss Varela was like, yeah, I think my sister was drinking that night too, so that may be why she didn't remember it, or that could explain what I said, I didn't think she knew about it, right? You heard her say that?
Yeah.
at no point after June 8th, 2022, did you go to Hannah Varela and say, ma'am, did you remember getting a text message on the night of a murder?
No, and I can explain why.
That's not my question.
Okay, no, I didn't.
Okay. So when Hannah or Hosanna is telling you this, and you know there's some discrepancies here, right? You never were like, I'm going to go interview Hannah, right?
No, I had every intention to go interview Hannah,
You never did.
and there's a reason why.
Why?
And Mr. Burros, I really don't like having to tell people the same thing.
I'm sorry, Your
And
Honor.
I'm really trying not to blow my stack here. It's been a long trial.
Okay.
This is not a conversation. Evidence is produced at trial through questions and answers.
Okay.
I need you to respond to the questions. The district attorney's office will have the opportunity to redirect if they choose to do so, and what they choose is important.
Okay.
But we're never going to get through this
Okay.
if you want this to be a conversation. So just, if it's a yes or no answer, or if it's a yes or no question, it should be a yes or no answer.
Okay, Your Honor, I'm sorry about that.
So never in the 3 years since Ms. Hosanna Varela's proffer did you interview Hannah?
No.
And again, all of these red flags and inconsistencies are important, especially in light of what you knew about Miss Varela and her ability to tell law enforcement the truth concerning in this case, right? And let me ask it to you this way.
Okay, I'm trying to answer yes or no, so
No, I
I'm
appreciate
sorry.
that. That was a bad question.
Okay,
Up until the proffer, your only experience with Miss Varela was the interaction that we saw in the parking lot.
correct, yes.
And again, the two women were contacted unexpectedly, and you actually spoke to Miss Varela first.
Correct,
And as we saw in the video, Miss Varela is taken from the driver's side of the Tahoe, right?
correct.
And she's removed from the Tahoe to the next vehicle over. That white SUV next to the Tahoe.
Yeah, after she's arrested, yes.
Yes.
Okay,
She's removed away from the Tahoe where Miss Rodriguez is.
yes,
And Miss Rodriguez is on the way other side, right?
correct.
And Miss Varela is with you, and I think is the officer or Detective Radin who also comes that we see in the video?
Yeah,
Brett Radin, I think you say something like, you okay, Brett, or something
Yeah.
like that? Okay. So she's with two police officers, right?
correct.
And you ask her a series of questions that we saw.
Yes,
And at every question, she lies to you.
yes, she does.
She lies to you even about where her mother lives.
I don't, sure, I don't remember that specifically, but she lied about everything that I could.
Everything.
Yeah,
So going up to this proffer, all you knew about this woman was that she lied to you at every juncture.
sure, yeah.
And also, presumably, when she's in this location and she's away from Miss Rodriguez is with law enforcement, she's with law enforcement, you guys aren't going to let anything bad happen to her in that moment, right?
No,
She's out of earshot from Miss Rodriguez, right?
I believe so, yeah.
And at no point does she say, hey, detective, I am terrified of that person over there.
No,
She doesn't say, detective or police officers, thank God, I'm glad you are, like, I can move a finger now.
and she said nothing like that.
Right. And throughout Miss Varela's proffer, there was also numerous times where she would refer to other people and how Miss Rodriguez's behavior towards her impacted them, right?
Yeah,
So we heard her testify that she had these prior domestic violence claims or alleged allegation, or I take that back, I'll strike that. We heard her testify that Miss Rodriguez, according to Miss Varela, was violent with her in the past,
correct.
right? And there was actually a time where Miss Varela described to you her children seeing bruises on her, right?
I don't remember that in the proffer. If it was, then it was in there.
Okay, would it refresh your memory to review that part of the proffer?
Sure.
Your Honor, maybe this may be a good morning break time. Can do that while we're breaking. Just
Sure,
for the
we'll
time.
go ahead and take our morning recess at this time. Give me just a second here. Ladies and gentlemen, I want to remind you that until the trial is completed, you must not discuss this case with anyone, either in person, using the internet, or by any other means. This includes members of your family, people involved in the trial, other jurors, or anyone else. If someone approaches you and tries to discuss the trial with you, or if you see or hear anything about it, even accidentally, please let me know about it immediately. You must not conduct any research, undertake any investigation, or otherwise obtain information about the case from an outside source. You must not read or listen to any news reports or internet information or other electronic sources about the trial. If there has been or is any news coverage of this case, you must completely disregard it. Your verdict must be based solely on the evidence presented in the courtroom and the law as I instruct you. Finally, it is especially important that you do not form or express any opinion on the case until your deliberations at the end of trial. With that, we'll be in recess. I'll ask that you report back at, let's make it 10:35. Please rise for the jury as they leave. All right, thank you. Please be seated. And the court will be in recess until 10:35.
Judge, I have permission to show these part.
All right. All right, and Cheryl, are you ready? Okay. The court is back on the record in 21 CR 2296, People of the State of Colorado versus Stacy Rodriguez. The parties are present as previously captioned, and we come back after our morning recess. Anything that we need to address from either side before we bring the jury in from the defense?
Your Honor, can we just talk about scheduling briefly?
Sure.
I think, Mr. McCormick, let me know if I'm wrong. I think this is their last witness. And we're just trying to coordinate our witnesses, including an experts, are coming in. So we're just trying to figure out when the court would be planning on breaking for lunch. I know we have two that are coming from like the Denver area.
Okay.
So
I don't know how much longer there is with Mr. Burrows, but if we need to address any motions in the Curtis advisement after lunch, I'm fine with doing that. I don't get the impression that you're 2 minutes away from finishing, but maybe you are. I don't know. If there was time before noon to do those motions and Curtis advisement before lunch, I probably would, but I can only guess as to whether or not they're.
right, I guess my question, sorry, was more of what time? Because I know we've been breaking from like 1 to 2.
So I don't need to go into the lunch hour today. So I would probably break close to noon.
Okay.
And like I said, if it's reasonably close to noon and it makes sense to do the motions in Curtis after lunch, then I'm fine with that.
I appreciate that. And can I just have one moment? My computer died when I was in there, so I just need to log back on if that's
Sure.
okay.
Okay. Just let me know when you're ready for the jury. And Mr. McCormick, anything from the state before we bring the jury in?
No, sir.
Okay.
tomorrow. Sorry, guys.
Are you ready, Ms. Devereaux? All right.
No,
If you,
it's freezing on the, so I'm just waiting for it to log on to the Wi-Fi.
oh, I'm sorry. Just let me know when you're ready.
I just didn't want you thinking I was just standing here not doing anything.
No, that's okay.
I think we should be good, thank you.
Okay. If you can bring the jury in, please.
Please rise for the jury.
All right, thank you. Please be seated. Mr. Burrows, I'll remind you that you are still under oath, and Ms. Devereaux, you can resume.
Okay.
Okay, thank you, and I appreciate it. So where we left off was I was asking you about Miss Varela describing to you during her proffer family members seeing bruises on her body,
Correct, yeah.
right? During her proffer on June 8th, she specifically described an instance where she was going into the bathroom and her daughter was like, "Can I go with you?" Remember that?
Yeah.
And then when Miss Varela described to you when she was changing, she had turned around and her daughter saw her changing.
Yeah.
And Miss Varela told you during this proffer that her daughter was like seeing the bruises and all sorts of cuts, right?
Yeah.
And at no point did you interview any of Miss Varela's children.
No.
Likewise, we heard testimony about Miss Varela having cuts all over her body,
Yeah.
right? And just so we're clear, you had 3 different sources of access to Miss Varela's phone. You had the original self-bright dump, right,
Correct.
via warrant.
Yeah.
You had the iCloud return that we've talked about.
Correct.
And then during the proffer, you asked Miss Varela for her password to her phone so you could have full access to it, essentially.
Yes, yeah.
Because sometimes with Cellbrite, if it's passcoded, you're worried that you may not be getting everything. Is that fair?
Yeah, that's correct.
And so you did 3 different Cellbrite dumps of Miss Varela's phone to make sure you had everything, right?
Correct.
And in addition to that, you also got all of the Facebook messages from Facebook records from Miss Varela too,
Correct.
right? And as we've heard Miss Varela testify, she took a lot of selfies, right? Is that fair to say?
Yeah.
There's a lot of pictures, right?
Yeah.
I think there was something along the lines of roughly 51,000 images on this woman's phone. Does that sound about right?
Yeah.
There's a lot of stuff to go through, right?
Yeah.
But as we talked about, you can, at the top of Cellbrite, there's like a time bar and you can pick the time to narrow it down, right?
Sure.
And there's like, just like any computer program, filtering options, right?
Yeah.
So you can pick like June, July, August, September, October, etc.
Yeah.
And after you hear about these cuts from her, the knife situation, we see it on the notes, you have now done at that point this third full complete Cellbrite dump. You never found any sort of images or pictures of all these cuts all over her body.
No.
You never found any kind of communication between her and Miss Rodriguez where she's like, hey, you put a knife to my throat. We're not cool, right?
Can't quite answer that yes or no.
Okay, that's fair.
Is that okay?
Sure. Let me ask you this. Nothing in any of this phone evidence, right, corroborated Miss Rodriguez having these cuts all, I'm sorry, Miss Varela having all these cuts all over her body.
I didn't see anything else.
And likewise, she described pretty a scary incident to you during the proffer, and then during my questioning with her of this really terrifying experience allegedly in September in a park, getting run over or almost run over, right?
Yeah.
She described to you being hit by a car and go flying, right?
Yeah.
And again, those 51,000 pictures, all of this cell phone evidence, nothing that corroborated that.
No.
Likewise, she described the field to you where this happened as like this open field with houses all around the perimeter, right?
For which instance? I'm
The
sorry.
September car incident.
I don't remember a field, but that could be accurate. I'm fine with that.
Well, you heard her testify about that, right?
Yeah.
Okay. And again, to your knowledge, no one ever reported this incident, right?
Not that I know of, no.
And what's interesting about that September car incident is she specifically told you during her proffer that while this is happening, she's on the phone with her sister, Hannah.
Sure. I don't quite remember if she was on her phone or not.
Okay, would it refresh your recollection to listen to that part of the proffer?
Yeah.
Okay. May I approach, Your Honor?
Yes, go
May I
ahead.
have freestanding to approach?
Yes, you may.
Thank you. So this is the proffer, and I'm going to start it for you at timestamp in the video is June 8th, 2022 at 9:17:52 seconds in the morning, and the actual timestamp into the video is 59 minutes and 18 seconds.
Okay. reference to the phone number just now. I just want to make sure I got everything. Yeah, I do.
Remember your question?
Yeah.
So again, during this crazy incident in September involving being chased in this open field in Evans, during the proffer, Miss Varela tells you that during it, she's texting her sister Hannah.
You're correct. Yeah.
And then at one point, she even tells you that she's like, I know my sister is coming, right?
Yeah.
She knew her sister was coming to pick her up and essentially be help for this incident, right?
Yeah.
And again, you never interviewed Hannah to verify any of that.
No.
Then there was also when Miss Varela is telling you about all of these allegations of domestic violence between her and Miss Rodriguez, she describes an incident where her mom seizes a bruise on her.
Okay. Yeah.
And you never went back to vet that out either and interview her mother.
No.
Likewise, we've heard that Miss Varela explained part of the reason why she never went to the police was because she was afraid Stacy would hurt Javi,
Yeah.
right? And you heard a lot about how Miss Varela had directly received these threats from Miss Rodriguez,
Yeah.
specifically pointed at Mr. Javier, what's his last name? Avia?
Avia.
Avia, thank you.
Yeah.
And again, through all these Facebook messages and all of the phone records, you didn't find any evidence to corroborate that.
As far as, can you
Sure,
help me?
Sure.
Sorry.
That's okay. You never found any threat to Javier's life in any of Miss Rodriguez's Facebook records
Not that I found, no.
or in any of Miss Varela's cell phone records or cell phone dumps.
No.
And you never also interviewed Javier.
No.
And Javier would have been able to tell you independently if he noticed Miss Varela not seeing her kids for extended period of time,
I think so, yeah.
right? I mean, he's their dad, right?
Yeah.
He also would have been able to tell you if, there was just something off about Hosanna when she was around Miss Rodriguez.
Judge, I'm going to object on speculation.
Give me just a second here. I'll allow the question. The witness can answer.
Well, can we approach?
Sure.
You can answer that question, sir.
I don't know what Javier would say.
And the point is, you never did that initial investigatory step on a first-degree murder case to verify what Ms. Ferrella was telling you.
As far as like talking to Javier?
Yes.
No, I didn't.
Likewise, you never talked to Hosanna's grandmother, right?
No.
And again, this is the residence where the phone last pinged to, right?
Well, it didn't ping to the residence.
Nearby.
Okay, yes.
Thank you for that clarification. So you never asked the grandmother if she noticed like a ring hanging around her residence?
No.
A ring hanging around her residence? Thanks, Cheryl.
Judge, I'm going to object again to the form of the question.
And-
He said he didn't.
And Mr. McCormick, I got it. I'm going to sustain the objection if the question is, if you didn't get any information because you didn't
Correct.
try. Let's just ask that.
Okay. So then we heard also about Ms. Ferrella's description about what happened at the Cosmic Mart. Perfect. Specifically, and we heard her testimony, and she also said the same thing to you on June 8th about who got what at the Cosmic Mart, correct?
Yes.
So according to her, do you recall who actually paid for the gas?
I think she paid for the gas, Hosanna.
Right. And she said that Ms. Rodriguez was the one who filled up the water bottles with the gas.
Correct.
And again, that would inherently be consistent with her being like, oh, I didn't know what we were going to do, right? About burning the house down.
I don't know if that's what she was thinking at the time.
Right, but that is what she told you, right? She told you that they drove to the gas station in complete silence, right?
Yeah, correct.
And that she didn't even know where she was going. She was just listening to Ms. Rodriguez say left, right, essentially.
Correct.
And that at the gas station, she's telling you, I didn't know what we were doing, right?
Correct.
And so certainly if she's only going in and paying $1 to a cashier, that's consistent with her being like, I didn't know what Ms. Rodriguez was planning. I didn't know what we were going to do, right?
Sure.
And the video, where you would agree with me that most gas stations in this day and age all have surveillance video,
Yeah.
right? And so had you gone to the Cosmic Mart or any of your colleagues to get a video from there, we would have known who paid for the dollar or who got the gas, right?
Yeah, we tried.
You tried?
Yeah.
Who did?
PST Canton went and looked.
Okay. And there was no video, right?
Yeah, there was no video. Their system was down, and then they weren't able to produce receipts at the time either. And this was prior to me interviewing Hosanna on June 8th.
One moment, Judge. Right, we're going to come back to that point, okay?
Okay.
So whether Miss Rodriguez grabbed the beer bottle with her hands and smashed Mr. Dickerson in the head or not, you would agree is a crucial point in this case,
It's an element of the case, yeah.
right? Because that would mean Miss Rodriguez was the initial aggressor, right?
Yeah.
Right? That would have to do with whether or not Miss Rodriguez acted in self-defense, right?
Yeah.
And Miss Varela is the only, again, source of this information, right?
Yeah.
And when she described this to you back on June 8th, 2022, she told you at one point, Stacy grabbed the beer bottle and threw it and missed, right?
Yes.
And then a second time, she grabbed a second beer bottle, right?
Yeah.
Smashed him on the head, right?
Correct.
And she used that word smash, the beer bottle, right?
Something to that effect, but that seems right.
Okay. At no point did she tell you on June 8th, 2022, that she saw Miss Rodriguez grab a third beer bottle, make contact twice.
I can't answer that yes or no.
Okay. Did Miss Varela never describe to you on June 8th, 2022, seeing Miss Rodriguez grab 3 beer bottles?
She did, yes.
No, she didn't, right? Your testimony today is that she did.
Yes.
Your Honor, I'm going to request permission to play some impeachment video.
Can the parties approach?
Sorry about that. And just for the record, it's the timestamp on the video is June 8th, 2022, and it's going to be at 10 o'clock and 41 seconds.
Okay.
Well, is this an exhibit that's being admitted? What are we doing here before we play it up?
It's an impeachment clip.
Okay.
And regardless of whether it is 2 or 3 beer bottles, as we heard, she used the specific language of smash, right?
Yeah.
And she described to you that the smashing of the beer bottle caused Mr. Dickerson to bleed, right?
Yes.
And as we've heard from your colleagues, both fired colleagues and law enforcement colleagues, that house was carefully searched through over the course of a couple days, right?
Correct.
In fact, I think some of your colleagues, Detective Blair, DeSandre, even like videotaped as they're going through things, right?
I think they had just their body-worn cameras on.
Do you recall one of them actually setting up a camera at the outside of the house too, looking in?
I think Blair did that.
Yeah. And these are also obviously trained detectives, right?
Correct.
They're also trained arson investigators, right?
Correct.
And can I approach, Your Honor?
Yes, go ahead.
As we've heard testimony, your colleagues found the pumpkin beer cans, right?
Correct.
They packaged those, put those into evidence, right?
Correct.
They even found this, which is prosecution's exhibit number 146, a single brown Budweiser bottle, right?
Correct.
And that this was found outside of the residence, right?
Correct.
And they carefully packaged this, right?
Correct.
Logged into evidence at the Greeley Police Department,
Yes.
right? And we also know that glass just doesn't burn in fire unless it's prolonged fire, right?
I don't know exactly the science behind that.
Okay. But we know that Mr. Dickerson's marijuana pipes did not burn in the fire, right?
The ones in the room?
Any of them,
No.
right? Because they're in evidence, right?
Yeah.
We also know that inside of Mr. Dickerson's house were some rum bottles that were found. Do you remember that?
I know there was like bottles found. I don't recall rum specifically.
But they were like black decorative rum bottles that clearly were not burned, right?
Are you talking about the ones on the shelf?
Yes.
Yes. Yeah.
Okay. And those did not burn, right?
No.
And yet the only glass brown Budweiser bottle found anywhere on Mr. Dickerson's property was that.
As far as I know, yes.
And as we can see, it's not cracked, right? It's not smashed.
No.
Even nicely has the label on it still, right?
Yeah.
So no broken brown Budweiser bottles were ever found in Mr. Dickerson's residence.
Not that I know of, no.
So that would be inconsistent with Ms. Varela telling you Ms. Rodriguez smashed a Budweiser bottle on Mr. Dickerson's head.
I can't answer that yes or no.
And when officers go through the process of, scene investigation, especially a case like this, they're going to package evidence a certain way. Is that correct?
Yeah.
You're trained how to preserve the integrity of evidence, right?
I would assume so.
Right. And actually, just so the jury's clear, when we are talking about packaging evidence such as this bottle, it's not put in this clear bag.
No.
This is just demonstrative so everyone can see it, right?
Correct.
So it's repackaged for purposes of a trial.
Yes.
And the actual original packaging from scene to the Greeley Police Department involves these bags, right?
Correct.
These special brown evidence bags.
Correct.
Why are these evidence brown bags used, these brown ones?
Because they allow air to filter in, so there's no mold or mildew that develops with any sort of liquid, if we put them in the regular K-Pack bags, the plastic, you'll get mold and it'll ruin the evidence.
How will it ruin the evidence?
Well, it'll make it mildewy and mold will grow on it.
Okay. And so when we put evidence in these brown bags, they're also carefully sealed so that no one's messing with the evidence as well.
Correct.
And these brown bags are really also important so that any kind of forensic evidence is preserved.
Yeah, absolutely.
And obviously for that same reason, officers always wear gloves when they do this, right?
Correct.
And with Mr. McCormick, yesterday, you testified, kind of got ahead of me and we're talking about all of the ways that forensics or forensic science can help verify witness statements, right?
Just verify evidence on hand.
Right.
Yeah.
Because science is objective, right?
Hopefully.
Hopefully, in theory. But and he went through a list of things such as DNA evidence and latent prints. And you're like, I can't do that because in this case, because the house, there's water, you know? But that came from a trash can outside, right?
Yeah.
So that wasn't destroyed by water, right?
No.
In fact, the labels isn't even like, you know how labels get wet, they kind of wrinkle?
I'll say that bottle is pristine.
Thank you, I appreciate that.
Yeah.
And the one piece of forensics that you did not mention yesterday was serology testing.
No, I did. I said DNA or serology.
Okay, so let's explain to the jury a little bit more about what that is, okay? So there's something called a I'm gonna probably butcher this, phenolphthalein reagent.
Okay.
Does that sound right?
Sure.
Okay. And so what that means is essentially you have a way of taking a piece of evidence, right? Is that yes?
Yeah.
And filling out a worksheet,
Yeah.
right? Sending it off to the lab.
Yeah.
And this is, again, very basic. I understand that.
Okay.
And saying, will you please test to see and identify what type of biological substance, if any, is on this particular item,
Yeah.
right? So had the only bottle found on Dickerson's property been used, again, similar to what or consistent with what Ms. Varela is telling you, to smash Mr. Dickerson in the head, causing him to bleed, presumably there would be blood on it, right?
If you're saying if that's the bottle that was used?
Yes.
Then yes, there could be.
Especially since that's the only bottle you ever found.
Correct.
And you and your colleagues at the Greeley Police Department routinely send out items of evidence out for this serology testing.
Sure.
And you say, dear science, please tell me what biological substance, such as blood, is on this, if anything, right?
Correct.
And that phenolphthalein, and I'm going to pronounce it or spell it for the record, just so we're clear. Do you need me to?
I actually have it, thank you.
Okay, great. And what that is sort of a reactant that you spray on an item, turn the lights off, and if there's blood, it glows.
Yes.
And that is different. It's kind of that can actually be done as sort of a on the scene thing that you and your colleagues can do, right? It's like an initial test. Is there blood on this item?
I don't know. I don't know that we have done that.
Okay.
Okay. I can't speak to that.
Okay, but you have the ability to send it off and
Yes.
And the point is, sir, is you knew that this was a key piece of the case, right? Was Mr. Dickerson smashed in the head or not, right? And the only source of that is Miss Varela.
Correct.
And this is the only glass bottle you found in that house, and you never bothered to send it out for any sort of science that would tell you, is there blood on it or is there not?
I did not send that bottle off, no.
And this has just been sitting in evidence for the last 3.5 years, right?
Yeah.
And never been tested.
No.
And so let's talk about what that means. The decision not to test that item, or let me ask you this. Testing that item would have either had two results, right?
Okay. Yeah.
Right? There's either blood on it that corroborates Ms. Varela's story.
Okay.
Is that fair? If you
If we're, I can't answer that yes or no.
So let me ask you this.
Okay.
If you had sent it out for testing and it came back that there was blood on the bottle, that would corroborate Ms. Varela's story about being smashed in the head and him bleeding as a result of it.
It could potentially.
Right. Otherwise, the second option is that it came back with no blood on it, right?
Correct.
And that would have been problematic because that's the only beer bottle found on that property, right?
Can't fully answer that yes or no.
Sorry. If that beer bottle, if the science told you that the only beer bottle found on Dickerson's entire property was not only intact, not smashed, but also did not have any blood on it, that would be potentially exculpatory evidence for Ms. Rodriguez.
I can't answer. I'm not trying to be difficult. I really am not. It's hard for me to answer that yes or no.
Regardless, we don't have that answer because you made the decision not to just fill out a worksheet and send it off to a lab like you and other officers routinely do at the Greeley Police Department.
I did not send it off.
And sir, you made that decision in a case where someone's being accused of first-degree murder.
Yes.
You made that decision in a case where a 19-year-old is being, at the time, accused of first-degree murder, and the only evidence you have that she did not act in self-defense is Ms. Varela's story,
Correct.
despite all of the red flags in Ms. Varela's story, right?
I can't answer that yes or no.
Despite Ms. Varela's, well, let me ask you this. There was also another piece of physical evidence, right? Can I have People's Exhibit 48, please? Would you guys mind publishing? Or is the computer off? Huh? Yep. Can I push the exhibits?
Yes, go ahead.
said.
48, please. Thank you. There's the Zales box, right?
Yes.
And so you were sitting through this trial, right?
Yeah.
I'm sorry?
Yes, I was.
Thank you. And so you were present when Lieutenant Cobb testified?
Yes.
And you're aware that Lieutenant Cobb told this jury that that Zales box with the jewelry appeared to have not been open at the time of the fire.
I don't remember him saying that specifically.
Okay. You don't remember him testifying that the box appeared to have, let me get his exact language. For Peoples of 48, he testified, do you recall him saying that the Zales ring box was closed?
I don't. I thought he was. I can't answer that yes or no.
That's
Okay. I'm sorry. I'm really trying not to be difficult.
No, I know. I appreciate that, sir. But the point is Miss Varela told you that Miss Rodriguez was the one who took the ring out of this box, right?
Yes.
At no point did you send that off for DNA testing.
No.
May I have one moment, Judge?
Sure.
Thank you, Detective. Nothing further.
Okay, thank you.
All right, thank you. Any redirect examination, please, go ahead.
Do you want me to go ahead and start? It's going to be lengthy, so do you want me to start now, or do you want to?
If you think it's appropriate to take a break first, we can go ahead and do that. Is that, okay. All right, ladies and gentlemen, let's go ahead and break for lunch a little early. Before I let you go, give me just a second. I want to remind you that until the trial is completed, you must not discuss this case with anyone, either in person, using the internet, or by any other means. This includes members of your family, people involved in the trial, other jurors, or anyone else. If someone approaches you and tries to discuss the trial with you, or if you see or hear anything about it, even accidentally, please let me know about it immediately. You must not conduct any research, undertake any investigation, or otherwise obtain information about the case from an outside source. You must not read or listen to any news reports or internet information or other electronic sources about the trial. If there has been or is any news coverage of this case, you must completely disregard it. Your verdict must be based solely on the evidence presented in the courtroom and the law as I instruct you. And finally, it is especially important that you do not form or express any opinion on the case until your deliberations at the end of trial. With that, we'll stand in recess until 1 p.m. Please rise for the jury. All right, please be seated.
Cheryl, I'm sorry. I think I misput that in order.
Okay. And the court will be in recess until 1 p.m. We're good. All right, the court will call 21 CR 2296, People of the State of Colorado versus Stacy Rodriguez. The parties are present as previously captioned. We come back after our lunch recess and we are outside of the presence of the jury. Mr. Burrows has retaken his seat at the witness stand. Is there any other issues that we need to address before we resume from the defense? No. Anything from the state? No, sir. Okay, thank you. All right, let's bring the jury in and we'll get started.
Thank you, Judge.
Thank you. Please be seated. Mr. McCormick, any redirect examination? Go ahead, please.
Yes, thank you. So Detective Burrows, when we last, or when you left off after your cross-examination, there was some discussion about the Budweiser beer bottle,
Correct.
right? Now, where exactly was that located,
In the backyard in a trash can.
right? And do you recall approximately how far away from the house it was?
I don't know exactly how far away it's from the house, but it's like your typical trash can that you would put out for the trash company to collect.
Right? And was there any indication that the container or the garbage can, whatever, had any type of fire damage to it?
No.
Right. Now, you were the lead investigator on the case, and you sat through this trial.
Yes.
You heard the testimony from Lieutenant Greg Cobb,
Yeah.
and you've heard from the testimony of other individuals that were charged with going through the house after the fire.
Yeah.
Was there a significant amount of glass in the living room area?
Yes.
If we could publish people's number 20, please.
All right, go ahead.
So what are we looking at here?
That's the living room of Christopher Dickerson's residence.
Was there a significant amount of debris in that living room?
Yes.
Are you able to determine if that object in the middle was where the couch was?
So I can point it out. That's what's left over the couch.
Right. And based upon the investigation, your information, as well as what then Lieutenant Greg Cobb testified to, was there a significant amount of glass on that floor?
Yes.
When you reviewed the videos of the body-worn cameras of Officer Flores, were you able to hear explosions in there?
Yes.
Were you able to hear glass breaking?
Yeah.
Do you recall Lieutenant Greg Cobb testifying that the front window is what failed and blew out?
Yes.
Once they were able to locate Mr. Dickerson's body, did they then, I want to call it, sift through that
Yes.
damage? All right. Was there a significant amount of glass?
Yeah.
What would have happened if you would have taken buckets of glass debris and sent those to the lab for testing?
Objection, speculation.
All right. Let me ask it this way.
If you'll rephrase,
Rephrase.
Mr. McCormick.
Would you have taken buckets of glass and sent them in for testing?
No.
Why not?
It would be difficult to differentiate between the glass, what was bottles, what was glass from windows. It's difficult to tell what glass is what.
And we know that per Lieutenant Cobb.
Objection, leading.
All right.
All right, I didn't quite get the question out, but Mr. McCormick, why don't you go ahead and I'll address that.
Try it again. Did Lieutenant Cobb tell you or testify as to where the fire started?
Yes.
Where?
In the living room.
Was that where the most significant fire or heat was?
Yes.
You recall viewing photographs of the bedroom of Mr. Dickerson.
Yes.
Were there still items in that bedroom that were intact?
Yes.
If we could show people's 32, please. This is Mr. Dickerson's bedroom.
Correct.
And what are we looking at here?
You're looking at some still intact objects and some debris on the floor.
33.
Again, more intact objects in his bed and then items on his bed.
All right, one more. 34, please.
Same view, but now you can see the closet and the bed.
All right. And do you recall if Lieutenant Cobb indicated that there was still, while still damage in this particular room, the fire was not that as hot in the bedroom as it was in the living room?
Correct.
All right. Now, there was also testimony or cross-examination about the discussion of the wallet and gift cards and victim's bank account. Do you remember that?
Yes.
And how none of that had been taken?
Correct.
And based upon your review of the victim's bank records, there didn't appear to be any inappropriate activity.
Correct.
All right. You know from your investigation, or do you know from your investigation, I'll rephrase it. Do you know from your investigation that Mr. Dickerson's phone was taken?
Yes.
That phone have value?
Yes.
Do you know from your investigation if Mr. Dickerson was missing a ring?
We couldn't find it in the house.
All right. Did that ring have value?
Yes.
All right. Now, you also had a discussion about search warrants.
Yeah.
Have you, in your career as a law enforcement officer, sought or obtained search warrants?
Yes.
All right. Has there ever been a situation where you had to have the DA call you and tell you to get a search warrant?
No.
Does that change your standard one way or the other?
No, I make my determination on what warrants I seek.
So what factors do you take into consideration?
There's a series of factors. The biggest ones we have to look at is articulable facts of the place that we're going to search and the items we believe we'll find inside.
All right. Are you familiar with the term probable cause?
Yes.
Do you know what that term means?
Yes.
What does it mean?
I guess the easiest way to explain it is it's more than likely that something happened or could be there.
All right. And is it true that in order to get a search warrant, it has to be supported by probable cause?
Correct.
And that's ultimately the determination up to the judicial officer?
Yes.
All right. Now, there was some discussion about having to go through the district attorney's office. Are you familiar with that process?
Yes.
Who instigated or instituted that particular process?
The chief judge.
Is that a protocol that's to be followed?
Yes.
Now, after the arrest of the defendant and Ms. Varela, which was on November 11th of 2021, based upon your investigation to that point, did you believe that you had probable cause, enough information to get a search warrant for Ms. Varela's grandmother's house?
I did not believe I did.
All right. There was some discussion on your cross-examination about whether or not Ms. Varela in her proffer ever mentioned or said the word gang in regards to the defendant. Do you recall that?
Yes.
All right. I'm going to hand you what has been marked as People's Exhibit 234 and 235.
You said 234 and 35?
Yes, yes.
And I'm sorry, can you?
I'm trying.
Sorry.
Yes.
To when? 13:45 what? To when?
Clip was 52 seconds.
Okay. 1 minute, please. You know, I don't. Chair, can you approach?
Sure.
That's fine. Should I get me to bring headphones so the court can listen to it?
What's that?
Get me to bring headphones so the court can listen to that?
If it's necessary, just in case. Objection, and will admit 234 and 235 into the record, and you may publish at your discretion.
Mr. Burrows, this is 234. just to clarify, you did admit these?
Yes, I've admitted both 234 and 235 into the record. You may publish at your discretion.
So let me frame this before we see it. Do you recall during your cross-examination that there was a discussion about whether or not during the proffer, Ms. Varela mentioned anything about the defendant being in a gang or some type of association? Recall that?
I remember that.
All right. And you've had an opportunity to listen to both of these
Yes.
DVDs. Your initials and the date appeared on as well.
Yes.
All right, go ahead and let's do 234.
When she was associated with because these like people like that she was associated with. I never like met them, and she was always like fearful of like them.
Is that like a global thing, or she's from California, right?
Yeah,
Was it a California thing or global?
She said that they were from California and her brothers were like involved with them. One of her brothers he's like in jail right now. And so I don't know if it would have been them.
Was she close to her family?
She was not really, but I know she was real close with one of her brothers. And that's the one that is in jail. She was the closest with him.
All right, so Detective Burrows, where did this proffer take place?
That's located in an interview room at the Greeley Police Department.
All right, and that's you in that picture,
It is.
and that's Ms. Varela,
Yes.
and is that her attorney, Ms. Lilly?
Yes.
Now, is that room obviously is audio equipped?
Yes.
Was that difficult to hear?
Yes. Very.
So on the table, if you'll look up there and take your pointer, there seems to be a little black box to your right. Can you tell, ladies and gentlemen of the jury, what that is?
That's my body-worn camera.
All right, and was that on and operational at the time?
Yes.
I'm going to ask the published pay 235, please.
Day or the next day, and I was like, who were you talking to that you told me about the fire? And then she goes, nobody. She goes, I didn't tell anybody. And then I was like, but I heard you on the phone. And she goes, I didn't tell anybody, don't worry about it. And she like gave me a kiss and then just went on. And so it never she never brought it up again. And so I don't know who she could have told her, but like throughout our relationship, like she was like associated with like these like people, like I don't know, like her like gang that she was like associated with. I never like met them, and she was always like fearful of like them.
Is that like a local thing, or she's from California, right?
Yeah,
Was it a California thing or a local?
She said that they were from California and her brothers were like involved with them. One of her brothers that he's like in jail right now. And so I don't know if it could have been like them.
Was she close to her family?
She was not really, but I know she was real close with one of her brothers, and that's the one that is in jail. She was the closest with him.
Okay.
But then
Detective Burrows, during that clip, did Ms. Varela use the word gang?
She did.
You also had during cross-examination discussion that you were shown by the defense this business about the beer bottles.
Correct.
And how many beer bottles were used?
Yes.
I'm going to hand you what has been marked as People's 236.
236, okay.
Yes, sir.
I'm sorry, 1750? The time. Do you know what the clip says?
I'm going to hand you what's been marked as People's Exhibit 236. Do you recognize that DVD?
I do.
Are your initials and the date on it?
Yes.
Have you had an opportunity to review it?
Yes.
Does it accurately reflect what's contained on the DVD?
Yes.
Thank you, Your Honor. At this time, I move into evidence People's 236.
Any objection to 236?
No.
All right, the court will admit 236 into the record, and you may publish at your discretion.
So just to give it some context, remember on your cross-examination, you were showing a clip by the defense that indicated Ms. Varela talking about just 2 bottles.
Correct.
Through the course of your interview with Ms. Varela, was there further discussion about the number of bottles that were used?
Yes.
All right, if we could play 236, please.
Is she, with him, or where is she at? Him, or where is she at?
I don't
in
think she's
relation-
on top of
Okay,
him.
so she's kind of standing, and then Chris is on the
Yeah.
couch.
Yeah, and I think he's trying to get up. I don't know.
Okay.
But and then she grabs the beer bottle and goes to hit him, but she misses. And I go, no, don't. I go, let's just leave it. You know what I mean? Like, let's go. And she looks at me and she I think she grabs another beer bottle, has that same one in her hand, and then that's when she hits him on the head, then gets another one, and then hits him again. And there's blood and blood on his face and everywhere on him and.
Okay. Let me.
All right, thank you, Detective Burrows. Judge, I don't have any further questions.
All right, thank you. Sir, you can go ahead and retake your seat. All right, the state may call their next witness.
We could have one moment, Your Honor.
Sure.
Can the court confirm that the people have admitted what's been marked and admitted as 1 through 186?
And Mr. Praley, it might be more fruitful to just come up here.
Sure, thank you.
107. No, I already showed 106. It was just 107. I'll have to follow up with you on that. All right, and I'm sorry, from the state, any further witnesses or evidence?
No, based on the exhibits that have been admitted at this time, the people that.
All right, thank you. Ladies and gentlemen, I need to take a brief break and have a discussion with the attorneys out of your hearing. So I'm going to send you back into the jury room for about 15 minutes or so. Give me just a second here before I let you go. I want to remind you that until the trial is completed, you must not discuss this case with anyone, either in person, using the internet, or by any other means. This includes members of your family, people involved in the trial, other jurors, or anyone else. If someone approaches you and tries to discuss the trial with you, or if you see or hear anything about it, even accidentally, please let me know about it immediately. You must not conduct any research, undertake any investigation, or otherwise obtain information about the case from an outside source. You must not read or listen to any news reports or internet information or other electronic sources about the trial. If there has been or is any news coverage of this case, you must completely disregard it. Your verdict must be based solely on the evidence presented in the courtroom and the law as I instruct you. And finally, it is especially important that you do not form or express any opinion on the case until your deliberations at the end of trial. With that, we'll be in recess for 15 minutes, and then we'll call you back in. Please rise for the jury as they leave. All right, thank you. Please be seated. From the defense, are there any motions at this time?
Yes, thank you. Your Honor, in this case, we're moving for a motion for judgment of acquittal and asking that the court dismiss counts 1 through 5 as the prosecution has not met their burden and the evidence is insufficient to be presented to a jury. Understanding, and I understand that the court is aware of the standard under People v. Bennett, as well as Colorado Rule of Criminal Procedure 29A, but for clarity purposes, 29A requires that the court, on motion of a defendant, shall order the entry of a judgment of acquittal of one or more offenses charged in the complaint after the evidence on either side is closed, if the evidence is insufficient to sustain a conviction of such offense or offenses. People v. Bennett does clarify that the evidence is viewed in light and most favorable to the prosecution. However, here, the evidence presented by the prosecution is insufficient to lead a reasonable person to believe beyond a reasonable doubt that Ms. Rodriguez is guilty of the crimes charged. We're making this motion based on the due process clauses of the U.S. and Colorado constitutions, which prohibit the criminal conviction of any person except on proof beyond a reasonable doubt. People v. Hollenbeck 944, Pacific 2nd 537, Colorado Appeals 96 states, the prosecution is given the benefit of every reasonable inference which might fairly be drawn from the evidence as long as there is a logical and convincing connection between the facts established and the conclusion inferred. If the evidence is such that a reasonable juror must necessarily have a reasonable doubt, the judge must direct an acquittal because no other result is permissible within the scope of the jury's function. This is People v. Bennett, Penn site 470. Now, understanding this inference in the light most favorable to the prosecution, the burden still remains upon the prosecution to prove each element of the charges beyond a reasonable doubt. As the court is aware, Ms. Rodriguez does not have a burden to testify or explain any of the allegations, and the court cannot consider the absence of such explanation in determining whether or not the prosecution has carried its burden. I'd like to start with count 1, which is murder in the first degree. The prosecution would have to prove that Ms. Rodriguez in the state of Colorado at or about the date and place charged, after deliberation and with intent to cause the death of a person other than herself, caused the death of that person or of another person. The court is aware of, under Leonard v. People, 369 Pacific 2nd 54 1962 that proof of killing alone is not murder. Proof of the mere abstract fact that the accused killed the deceased will not sustain a guilty verdict of first or second degree murder based on the instructions. Understanding that we will deal with jury instructions at a later time. First degree murder is a deliberate and premeditated killing of a human being. Okay. Do you want me to repeat that?
Yes.
Okay. First degree murder is the deliberate and premeditated killing of a human being as cited in Washington v. People, 405 Pacific 2nd, 735, 1965. Now, when we're looking at the elements of first degree murder, the prosecution has not been able to meet their burden in respect to elements 3 and 4. I do understand Dr. Burson had testified that the manner of death is homicide. As the court is well aware, as the prosecution is well aware, that's not a legal determination, but more of the medical determination. When a autopsy is being done, as Dr. Burson had testified, there are specific types or manners of death, and homicide is ruled as one when it's believed that the manner of death would not have been caused by that individual or an accident. I think the issue in the case before the court is that the evidence in regard to what had occurred in Mr. Dickerson's home in the morning of October 3rd is solely from one individual, and credibility becomes a component for the court here. Even understanding the lower burden that the prosecution has to survive a motion for judgment of acquittal, I would ask that the court consider what's been heard this week and last week in regard to Ms. Varela's credibility. Detective Burrows, it is clear through the evidence presented that besides Ms. Varela's statements on June 8th, 2022, Detective Burrows had no idea what occurred in the home. The prosecution did not know, really police department did not know. Now, Ms. Varela was provided a plea agreement from the same prosecution office and was given, well, one, she did not plead to first degree murder. She was given the opportunity of serving a sentence and the eligibility for parole. That is going to influence the way she testifies. The court also heard multiple different statements, her being impeached, and the prosecution spent a lot of time yesterday going back through Detective Burrows and trying to essentially corroborate what Ms. Varela was saying in a way that I don't think is actually material to the elements here of the car being driven, when they left the home. What actually is necessary to talk about the first degree murder is what had occurred in the home. Besides Ms. Varela, there is no corroboration that Ms. Rodriguez had any intent, that this was after deliberation, and the contrary is true because Ms. Varela had testified that Mr. Dickerson was making Ms. Varela uncomfortable, and that at one point Mr. Dickerson had cornered Ms. Rodriguez, so much so that he was towering over her and Ms. Rodriguez had to push him away. And this is solely coming from Ms. Varela. Within that same interaction, Ms. Varela changes and says that at that point, Ms. Rodriguez had asked for the metal file that the prosecution has admitted into evidence after she had hit Mr. Dickerson on the head with a bottle. As the court has heard, there are no broken bottles that were ever found. The prosecution has only been able to admit, I think what Detective Burrows said, that the bottle was in pristine condition. There's nothing to then suggest that what Ms. Varela has said is actually credible of what occurred to provide the prosecution with the sufficient evidence to submit it to the jury to prove with intent and after deliberation. I'd like to move on to count 2, which is the first degree arson. The prosecution would have to prove that Ms. Rodriguez unlawfully and knowingly set fire to, burned, or caused to be burned a building or occupied structure of Mr. Dickerson. The court heard testimony from Lieutenant Cobb, Mr. Eberly, Detective Burrows, Detective Blair, in regard, and had seen body worn from Officer Flores and Officers Berkeley, which showed that the house was in fact on fire. There were photos of the burned home. But the problem is that the prosecution has not proved that it was in fact Ms. Rodriguez who did this. Again, solely relying on an individual's testimony who was given a benefit from this prosecution's office that if she came in and told the same story that she told Detective Burrows, that she could then ask to reduce her sentence. So the fact that she has a massive benefit for this to then say something, pinning this on somebody else, is something for the court to consider. Absent Ms. Varela's testimony, the prosecution has the surveillance videos, and the prosecution has spent a lot of time going through each surveillance video, providing blurry screenshots of close-ups, of trying to suggest that Ms. Rodriguez was the individual who went into the home, and she was the individual who came out of the home after we can see light starting from the living room window. However, there has not been any evidence to confirm that this was in fact Ms. Rodriguez, again, besides Ms. Varela, who has that personal motive and bias and reason for pinning this on Ms. Rodriguez. The prosecution spent a lot of time looking at the license plate readers, especially, and I think it's important to contrast this with October 16th, where Detective Burrows said that he looked at multiple photos, looked at earrings, zoomed in, matched a shirt, and believed that to be Ms. Rodriguez. We have the opposite from the morning of October 3rd. What we actually have from October 3rd is one individual in a car, assuming so as the car is on. We see another individual go into the home and exit the home. But there is nothing to suggest that this was Ms. Rodriguez beyond a reasonable doubt. So we'd ask that the court also grant the defense's motion for judgment of acquittal as in regard to count 2. I would also adopt or ask the court to consider the same argument with tampering, as again, this was considered I think the prosecution's theory is very similar of Ms. Varela being in the car. However, if the prosecution is suggesting that the tampering, where they would have to prove willfully destroyed, mutilated, concealed, removed, or altered a human body, part of a human body, or human remains with intent to impair its or their appearance of availability in official proceedings, if the prosecution is, their theory is that this was based on count 2, which is the arson, we'd ask that the court consider that same argument. I do not believe that the elements would fit should the court find that the prosecution, or should the prosecution be arguing that the tampering allegation is when Ms. Rodriguez, according to Ms. Varela, had taken Mr. Dickerson off the couch and onto the floor. If that is their theory, there is likewise no evidence, even in the light most favorable to the prosecution, of this. Ms. Varela had said that Ms. Rodriguez had to, drag Mr. Dickerson's body from the couch onto the ground to make it look like self-defense. Besides, again, the self-serving statement to save herself a prison sentence without the possibility of parole, Ms. Varela had said that that's what Ms. Rodriguez did. There's nothing to suggest in any of the arson investigations, anything that Detective Blair had seen in the home, or Officer DeSandre, who the prosecution has not called, but anybody that had searched the home, there's nothing to suggest that the body was moved from the couch to the floor of where the officers or ultimately Mr. Dickerson's body was found. So in regard to count 3, we'd likewise ask that the court grant defense's motion for judgment of acquittal. Looking to counts 4 and 5, speaking, I guess, specifically with count 4 initially, as the underlying offense with the intent to commit a crime would be arson as elected by the prosecution. I think the same kind of argument does apply for count 2 the prosecution has been unable to prove that Ms. Rodriguez, beyond a reasonable doubt, was the one who went into the home and started the fire, which would have been the intent to commit the crime of arson. In regard to count 5, we are likewise asking that the court grant defense's motion for judgment of acquittal. For second-degree burglary, the prosecution has to prove that Ms. Rodriguez entered or remained unlawfully in the dwelling of Mr. Dickerson with the intent to commit a crime, and as they elected, that crime was theft. They had said cell phone and or jewelry. Mr. Dickerson's phone was never found. Detective Burrows had testified that Alan Dickerson provided him with a thumb drive that had Mr. Dickerson's Google takeout information, which showed kind of where his phone would have been located using the latitude and longitude from Google. There are two individuals in that vehicle. Ms. Varela said that she walked out with a backpack. Ms. Varela also said that at one point, Ms. Rodriguez then bleached everything and then set it on fire. The prosecution never found anything to support that claim. The detectives that have testified, the officers that have testified, Ms. Varela has not even provided any type of information to suggest that this actually occurred. So I think the issue here is when we have with the intent to commit the crime of theft, I don't believe that the entry or the unlawful remaining on a property with that intent has been met here. Furthermore, an engagement ring was never even found. And I think what the court should consider here is that when the prosecution had shown the court and the jury the Zales box that was on Mr. Dickerson's bed that was opened, there's an SD card in there. There is nothing to suggest there ever actually was a ring in there to begin with. The prosecution failed to call Bethany Cook, who was the individual who was a recipient of that ring at one point, to say, does this look like that? The prosecution said that they had witnesses testify that they had looked into things, that they had investigated the Zales, that they found a receipt in a car. Again, nothing is to suggest that this ring was actually ever taken or was available in the home to be taken. The fact that a jewelry box was on a bed that appeared to be open, also holding an SD card, is not sufficient for the prosecution to meet their burden that Ms. Rodriguez entered or remained unlawfully in Mr. Dickerson's home with the intent to commit the crime of theft, specifically in regard to the engagement ring. Again, no cell phone was ever recovered, no engagement ring was ever recovered, and the box that should have had an engagement ring was full of something else. Your Honor, I apologize if I just may have one moment.
Sure.
I would just like to note, for purposes of clarity for a record, but also, if at all helpful for the court, I think ultimately what we're looking at here is a basis of a presumption. And so People v. Madison, 638 Pacific 2nd, 1981, states that culpability cannot be determined on basis of presumption. The essential culpability for first-degree murder cannot be determined on the basis of presumption of law. Rather, the requisite culpability must be proven as a matter of fact. So looking at the totality of the circumstances here, the information that was provided, the lack of testimony from witnesses who would be able to corroborate what Ms. Varela is saying, the lack of investigation done by the prosecution to corroborate what Ms. Varela was saying, should lead the court to find that the prosecution has not met their burden here. And we would be asking that the court grant Ms. Rodriguez's motion for judgment of acquittal.
All right, thank you. Any response from the state?
Yes. I guess I'll start by asking the court if you have particular questions of elements that you'd like me to address.
I don't have any specific questions.
Okay. The court's well aware of the standard under Bennett and Rule 29 that the prosecution is given the benefit of every reasonable inference which might fairly be drawn by the evidence as long as there is logical and convincing connection between the facts established and the conclusions inferred. That's People v. Hollenbeck. The proper standard to be applied for the defendant's motion for judgment of acquittal is whether the relevant admissible evidence, both direct and circumstantial, when viewed in the light most favorable to the prosecution, is substantial and sufficient to support a conclusion by a reasonable mind that the defendant is guilty of the charge beyond a reasonable doubt. I think if the court views the evidence in totality as both direct and circumstantial evidence combined, the court does not have a tough decision before it. Specifically, all of these should be addressed by the jury, and they can make the decision as to each of these. If the court wants me to go through each of the charges for murder in the first degree arson, tampering with a deceased body, second-degree burglary with the basis of arson, and second-degree burglary as a basis of theft, I'm happy to answer any question that the court has. Well, in viewing the evidence in its totality, the people have more than met the limited standard that Bennett requires.
All right, thank you. When the court considers a motion for a judgment of acquittal, the court considers whether the state has met their burden of presenting evidence which, when viewed as a whole and in the light most favorable to the prosecution, whether that evidence is substantial and sufficient to support a conclusion by a reasonable person that the defendant is guilty of the crime beyond a reasonable doubt. When the court considers the evidence presented in this trial, the court does find that the state has met their burden as to counts 1 through 5, so the court will deny the defendant's motion for a judgment of acquittal. When considering a motion for a judgment of acquittal, the court is not to act as a 13th juror and is to respect the jury's province to be able to consider such things as witness credibility and the weight to be given various pieces of evidence. Much of the defendant's argument would require the court to make an assessment of specifically Ms. Varela's credibility. Based on the court's view of the evidence, the court does not find that the witness is incredible as a matter of law, and it would be inappropriate for the court to make specific determinations apart from that singular determination. So the motion is denied. From the defense, do you wish me to advise Ms. Rodriguez of her Curtis rights at this time? I would not be intending to ask her to make a final decision until the close of any other defense evidence that may be presented. But if you would like me to at least give her that advisement now so that you can have a discussion about it later, I'm happy to do that.
Yeah, that's totally fine, Your Honor. Can I have one moment? Because I need to pump, and I'm wondering if Ms. Rodriguez, if I could just have a chance to talk to her, if she's comfortable, just have Ms. Trujillo here for it while you give the advisement, and then I'll go pump if we can.
Sure, so you're going to step out and I'll give
I'm just going to check and see if she's okay with that.
Okay, all right.
Yeah, she's okay with that.
All right. Do you want to take Sam? If she needs it, okay. All right, so Ms. Rodriguez, I have a very important advisement that I need to give you at this time. There are very few points through this process where I directly address you, but this advisement is important enough that I need to directly advise you and make sure that you understand these very important rights. So please listen very carefully to the following rights. Ms. Rodriguez, you have the right to personally testify as a witness in this case if you choose to do so. If you want to testify, no one, not even your lawyer, can prevent you from doing so. If you choose to testify, you will not only answer questions asked by your lawyer, but you must then answer questions asked by the prosecutor. If you choose to testify, jurors may submit questions to the court for you to answer, and the same rules of law, evidence, and procedure that apply to lawyers' questions will apply to juror questions. Only legally proper juror questions may be asked. If you choose to testify and it happens to be a fact that you have been previously convicted of a felony, the prosecution would then be entitled to ask you about it and thereby disclose that fact to the jury. However, the court would then instruct the jury that they may only consider such prior felony conviction for the limited purpose of whether or not such a felony conviction affects your credibility as a witness in this trial. The court would also instruct the jury that a prior felony conviction may not be considered by the jury as evidence of guilt in the present case. From the state, is the state aware of whether or not Ms. Rodriguez has any prior felony convictions?
No.
All right, thank you. If you decide that you do not want to testify as a witness in this case, no one, not even your lawyer, can require you to testify. If you choose not to testify, the court will instruct the jury that they may not consider your failure to testify as evidence of guilt. It is the responsibility of your lawyer to give you advice as to whether your lawyer believes you should or should not testify as a witness. You should listen to and consider your lawyer's advice, but it is important that you understand that you are not required to follow your lawyer's advice. Ms. Rodriguez, do you understand these rights as I've explained them to you?
Yes.
And do you have any questions for me right now about those rights?
No.
All right. Ms. Rodriguez, I'm going to give you some time to discuss the matter with your attorneys, and I will rely on your attorneys to tell me when is an appropriate time for me to inquire what your ultimate decision is. When I do, if you need me to go over any of those rights with you again, I'm happy to do so. Just let me know.
Okay, thank you.
All right. Ms. Trujillo, you want to stand in recess for about 10, 15 minutes? Does that about sound right?
Yes, I think we'll need at least 15 is how
Okay.
I've been tracking for time.
All right. Then we'll go ahead and be in recess for another 15 minutes. Let's plan on resuming at 2:25, and then we will proceed with any defense evidence if there is any. And Ms. Trujillo, without asking you to disclose too much, it sounds like there is the possibility of at least one witness. Is that an accurate statement?
Yes, and we do have 2 witnesses here.
Okay, thank you. All right, court will be in recess. Will you let the jury know? It'll be 2:20. Can you check that out, Sonia? And if we need to go on the record to sort that out, we will. Okay. All right, thank you. We are back on the record in 21 CR 2296, People of the State of Colorado versus Stacy Rodriguez. The parties are present as previously captioned. We come back after our recess and we are outside of the presence of the jury. Just for the record, to memorialize the discussion that we just had with Mr. Pralia and Ms. Trujillo, off the record, on conferral with my staff and the court reporter, it does appear that Exhibit 107 was not admitted. Mr. Pralia, Mr. McCormick, I know you had mentioned earlier, but for the record, how would the state like to proceed as to that issue?
As previously stated, the people are not asking to open the evidence back up. I know that the court had stated at the bench conference that you, based on the court reporter having it in her notes, you believed it was. Looks like ultimately that was not the case, but again, we're not trying to admit 107. It's contained on other exhibits.
Okay, all right. Then I will consider that issue resolved unless the defense has to make a record as to that.
No, thank you.
Okay. Then are there any other issues that we need to address before we bring the jury back in and proceed with any defense evidence?
Can I just have one moment, Judge?
Sorry, Your Honor, can I just have one moment?
Sure, absolutely.
We're ready, Your Honor. Thank you.
All right. Anything from the state?
No.
Okay, let's bring the jury back in and receive.
Yeah. I'm just wondering. No.
what are we to for exhibits?
All right, thank you. Please rise. All right, thank you. Please be seated. Does the defense wish to present any evidence at this time?
Yes, please. At this time, we would call Miss Mary Claire Mulligan.
All right, thank you. Go ahead. Thank you. Ms. Mulligan, if you'll please come forward, and if you can just stand in front of the witness stand before you sit down, please. Thank you. And if you'll please raise your right hand. Ma'am, do you swear or affirm under penalty of perjury that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth? Thank you. Ms. Mulligan, if you'll go ahead and have a seat. Thank you. And ma'am, if you can just get as close as is reasonable to the microphone, that will help our reporter a lot.
Okay.
Ms. Devereaux, you may proceed when you're ready.
Thank you. Or afternoon, ma'am. How are you?
I'm good. How are you?
Good. Can you please state your first name and last name, spelling your last name for the record?
Mary Claire Mulligan. My last name is Mulligan.
Thank you, Mrs. Mulligan. Ms. Mulligan, what do you do for a living?
I'm a criminal defense lawyer.
Okay. And can you tell me about the education that you've received to become a criminal defense attorney?
Yeah. After undergraduate school, all lawyers have to go to law school. I went to the University of Colorado Law School. I graduated from there in 1992. So I've been a lawyer, criminal defense exclusively for 33 years almost. And then basically once you've graduated from law school, you take the bar and bam, you're a lawyer.
Okay. Do you have to have so many continuing learning education credits or classes taken throughout the year or cycles of years to maintain your license as a lawyer?
Yes, they're called CLEs, continuing legal education credits, and we do 45 every 3 years, I believe. It's the kind of thing where lawyers generally are teaching other lawyers about different techniques, ways to improve as a lawyer. I frequently teach these to other members of the criminal defense bar in the fields of, different topics within criminal defense, criminal ethics, criminal procedure, that kind of thing.
Thank you. And you mentioned that you've been practicing criminal defense exclusively?
Yes.
Since 1992, is that correct?
Yes.
And so can you estimate for the jury approximately how many clients who have been accused of crimes that you've represented since your career began in 1992?
I usually say 3,000. However, when I left I was a public defender in Adams County for 5 years. So when I left there in 1997, I'd already represented 1,800 people. Much less of a caseload now that I am in private practice, but it's well over 3,000 people.
Thank you. And what types of cases has that included?
Every possible kind of criminal case. I do both state and federal work. So sometimes I go to federal court and handle the kinds of cases you hear about there. In state court, I have done every possible kind of case from DUI through death penalty cases. Usually I do more serious cases though.
Thank you. And have you also testified before any kind of legislative bodies regarding criminal justice related issues?
Yes, multiple times, including this session.
And are you published in the field of legal practice as well?
I am, kind of. I wrote a couple articles that were published in the Colorado Lawyer and in the local bar association newsletters, things like that. My main thing really is I teach a lot of CLEs. I try to stay on top of everything because that's really why I became a lawyer, to learn more and help other people learn.
Have you recently won an award regarding your legal practice in criminal defense?
Yes. Last year, I won an award given by the Colorado Criminal Defense Bar for outstanding service to the profession without regard for personal gain, meaning you don't get paid very much.
Thank you for that clarification. And have you been accepted by any courts as a witness, as an expert witness in the practice of criminal defense?
Yes, I've testified as an expert witness in the field of criminal defense in Larimer County, Adams County, Arapahoe, and Denver.
Thank you. Your Honor, at this time, I would move to admit Ms. Mary Claire Mulligan as an expert in the legal practice of criminal defense pursuant to 702.
Any objection?
I don't have any objections.
All right, thank you. I will accept the witness as an expert in the proffered field, and Ms. Devereaux, you may proceed accordingly.
Thank you. Now, Ms. Mulligan, I think we have to go over this obvious question of, are you being compensated by my office for your time?
Yes, hopefully.
Hopefully, that's always the key. But is it a substantial amount of money?
It's $118 an hour.
And approximately how many hours have you worked or plan on working in this case?
I assume it will be less than 10 hours.
Okay. Is that enough money to sway your opinion in this case?
No, but if you have a better offer, I definitely would be interested.
That's fair.
Many times, as an expert witness, we're approached by a lawyer, and usually it's not in a trial situation, it's usually in a different situation, and we'll look at the case and say, you know, I'm not going to be able to agree with what you want me to say, so I'm not going to take that case. I do make more money practicing law than testifying as an expert, so, you know, obviously you guys will decide whether you think I'm swaying my testimony in any way because of the money compensation. It's good money. I'm not complaining. I mean, I make a decent living.
Thank you for that. While representing over the 3,000 approximate clients accused of crimes over the past, again, approximate 33 years of your career, have you ever had any experience with the legal process known as a proffer?
Yes.
And can you explain to the jury what that general legal term, again, a proffer means, please?
Yes. It has a couple of different meanings, but my understanding is that what you're wanting me to explain is the type of proffer where a client or defendant tells their story to the prosecution as sort of a preview. That's kind of how I like to remember the word proffer. It's like offer with a preview on, you know, PR in the front for either a preview or proposal or, you know, sort of a little hint at what someone would have to say were they to ultimately testify in a case against someone else.
And can you also explain, I'm just going to do some sort of general legal terminology, what a plea bargain is?
Yeah. A plea bargain, probably like you've seen on TV, is an agreement between the client, represented by their defense lawyer, and the prosecution. And a plea bargain can be something like, okay, well, I'm going to plead guilty to a less serious offense and avoid going to trial where I would risk being convicted of the more serious offense. So many times that's what it is. Sometimes the issue is I'm trying to get a stipulated sentence or a better sentence for myself. And so I enter into a plea bargain because I don't want to take the risk of going to trial and possibly losing on the most serious thing that I'm charged with. I'm pleading to a lesser charge or a stipulated sentence or the possibility, of a lesser sentence so that I know what I'm looking at. Some people just like the, no risk.
And in the context of a criminal matter, who is giving that sort of plea bargain?
The prosecution.
Does the court give plea bargains?
No, the judge will decide whether to accept a plea bargain. So in other words, the prosecution is the one that has the power because they're the ones who did the charging. They made the decision as to what charges to file against a person. They can then decide, okay, well, I think this guy should get a deal that, let's give him a 10-year deal. This actually just happened this week in federal court here where one of our federal judges denied a plea bargain because she thought it was too lenient. So rarely happens, but that's the judge's real only input into the plea bargaining process.
Thank you. So in the context of criminal cases and plea bargains, can you explain to the jury what a proffer is?
Yeah, so when you want to have a proffer situation, it's very, very common in federal court. Not quite as common in state court, but it does happen. What happens usually is one side or the other will reach out to the other side. Sometimes it's the prosecutor, sometimes it's the defense lawyer. And what they want is, hey, maybe we can make this case work out and get to a plea bargain. And the way we're going to do that is this client has information that he wants to bargain away to the prosecution in exchange for a better deal. That's basically how it works.
And again, have you dealt with this process of a proffer before in your own practice?
Yes.
Now, do proffers typically happen on misdemeanors or not so serious cases?
Not usually. I mean, usually it's on serious cases for a couple of reasons. Although you didn't ask that, so maybe I should keep my mouth shut until you ask that, if you want to know why.
Why? Please go ahead.
Misdemeanors are really usually not serious enough to warrant something as time-consuming as entering into a proffer. One reason it comes up more in serious cases is, for one thing, many times there are co-defendants. Usually when a proffer happens, it's a co-defendant situation. And what the person does is say, hey, I'm willing to testify against my co-defendant if I get a better deal. Like I said, that's usually in that kind of situation, you're looking at a more serious case. And in federal court, the reason for why there's so many proffers in federal court is that in federal law, there are very specific mandatory minimum sentences in drug cases, and most federal cases tend to be, that's a large portion of what a federal caseload is drug cases. The only way to avoid a client facing a 10 or 20-year mandatory minimum sentence is by proffering, because if the proffer's accepted by the prosecution, the law is written so that the person doesn't have to actually serve that full mandatory minimum.
Thank you. So are proffers typically, in your experience, given to someone accused of a crime by a prosecutor if they have, let's call it a slam dunk case? Well, let me ask it this way. Do proffers typically occur in cases where prosecutors need additional information?
In state court, yes.
Okay. And are proffer agreements typically extended by, or let me ask you this. You said earlier that either the prosecuting attorney or the defense attorney will reach out, right? Mm-hmm. And once that happens, does the defense attorney or the person they represent get a firm answer ahead of time about what that benefit is going to be?
Not necessarily. So in federal court, you kind of know what's going to happen because, again, there are specific rules for federal court. If you proffer, you know already what sentencing range the client is looking at, and so the federal prosecutor will give them a percentage off their possible sentence, and that percentage can range from like 10 to 50%. So you know that somewhere in that 10 to 50% range, lower than what the sentence would have been, is where you're going to end up with a federal proffer. With a state case, you have to write that in so that you know what the benefit for your client is. Like maybe you say, hey, if we proffer, will you be willing to give me an F2? Or will you be willing to stip to 30 years or whatever it is?
Okay. Now, is it fair to say that proffers in state court usually happen in a case where there are issues the prosecution wants to know, such as like where a body is buried, or what happened in the last minutes of someone's life, or who yielded the murder weapon?
Yeah, sometimes, especially in more serious cases, there are questions that the prosecutor wants to know. An example is a case that I had a couple years ago where it was a first-degree murder case. 3 people were killed, and there were multiple people who law enforcement believed were involved. They charged my client, and they did not charge anyone else because they just didn't have the evidence to charge someone else. So they said to us, hey, if you proffer, we'd like to know who else is involved.
Okay. And once the proffer proffer process is started, are you familiar with any kind of standard letters that prosecutors give to that attorney about along the lines of, your client so-and-so has expressed an interest in talking with our office?
Yeah, typically called a proffer letter or proffer agreement, and usually the prosecution drafts that up.
And were you able to provide redacted copies for this case for both the state of Colorado case and also a federal case?
Yes.
And would you recognize those?
Yes.
Your Honor, I'm showing the prosecution what's been marked as proposed defendants exhibits E and F.
E and F, go ahead.
Bless you.
Judge, I don't object to defendants F. I do object to defendants E.
All right, I will admit F into the record, and if the parties can approach with E so I can look at it.
So this time I'd move to admit E and F, Your Honor.
All right, I will admit E and F. And
Thank you.
Can publish when appropriate.
Okay, so are these proffer agreements pretty standard?
Yeah, every jurisdiction may have slight differences, and they do evolve over time as different cases come out and things change. But there's usually a standard in all the jurisdictions where I've done it.
Now, you talked about why someone accused of a crime would proffer. I want to now switch to why a defense attorney would agree to a proffer, okay? In general, will a defense attorney at the state level get a specific deal for their client ahead of proffering?
It might not be completely, written into stone, but oftentimes it will be, here's what we're thinking about giving you in exchange for the proffer. If you can give us the information that we need, then we will give you an F2 or 30 years or whatever it is.
What's an F2?
Class 2 felony.
And so is that ever written down? Like, does the defense attorney get an email from the prosecutor saying, if your client gives us information, we promise the F2, or we promise 20 years?
Yes.
In state court?
I mean, is it ever written down? It usually you get information ahead of time. They may not write it down, but they've said it to you. I think it's best practice to get it in writing because the guy drops dead tomorrow,
Right.
you're stuck.
Right. Now, are there times where defense attorneys agree to proffers without an agreement?
I hear that does happen.
Okay. And what are your thoughts on that?
The reason as a defense lawyer first of all, the defense attorney and the prosecution are on opposite sides. That's probably very obvious to you. But so as the defense lawyer, you're handing your client over to the prosecutor essentially during a proffer. You are sitting there while the client tells the prosecution the worst things they could possibly be telling them, stuff that will really hurt their chances at trial. So as the defense lawyer, you need to try to control or limit whatever damage might happen. That's why you want to get agreements in place, have everything worked out. The one thing about, when you were asking me about law school, one thing law school does to you is it makes you look for the worst case scenario and plan ahead for it. So as a defense lawyer, it's very nerve-wracking to have your client proffer because, like I said, they're running their mouth and you can't control it. We like to be in control when we're in the courtroom or out of the courtroom. Our job is to be in control of the situation in a way that our client doesn't hurt themselves more, and preferably that you get some kind of benefit for the client. So if you walk in cold and you're basically just throwing it out into the wind, here's my client's confession. What you're doing is banking on the prosecution liking what your client has to say and giving you an appropriate benefit for it. If you bare your soul and tell them everything they want to know about a particular case or their role or whatever it is, you are completely at the mercy of the prosecutor. So that's why defense lawyers usually try to avoid that. The only reason you would do that is if you really, really trust the prosecutor and you know that you're getting some benefit on the back end after you've already testified.
So is it fair to say that, let me ask you this, would it be ethical for a defense attorney to walk their client into a police department to talk about what happened in a crime without having that reassurance that they were going to get some sort of benefit and it was going to work out for their client?
It would not be ethical. It would not be competent.
And when we're talking about like ethics and competence, are lawyers governed by certain laws concerning that?
Yes, people are always surprised to hear that we have ethical rules, but we do. And one of the main ones is you got to be competent. You have to know what you're doing. And it's kind of like, they say about doctors, first, do no harm. I mean, you definitely don't want to ever do something that could hurt your client. Confessing is the absolute worst thing. Well, one of the worst things you could possibly have a client do. Whenever you hear that somehow your client has said something that has made them seem guilty, it's always devastating to their case. And so that's something you want to avoid. You don't want to say, hey, go confess. I mean, it goes against not only your own self-interest as the person talking, but from the lawyer's perspective, it's the opposite of what we want.
Now, do proffers, though, always work out?
No, not always.
And what do we mean when we say work out?
What I would say is if a proffer works out, you get the plea bargain. You make your statement and you're able to enter into the plea bargain and everything is great. If a proffer doesn't work out, what happens is you have a proffer and the prosecutor is not satisfied with it, not happy with it, and is like, I'm not giving you the deal because whatever. Either I don't think you were telling the truth in the proffer, I don't think you were telling all the truth in the proffer, I don't need your client's testimony anymore, all of that. There are various ways in which it could go south, which is one of the reasons it's a very nerve-wracking experience for a defense lawyer.
Do these proffer agreements typically include some sort of incentive that hangs over the heads of the person who proffers, depending on their testimony?
It may not be written into the actual proffer agreement, but there is, I mean, obviously the ultimate incentive is you're getting a better plea bargain, you're getting a better sentence, et cetera, in exchange for your story.
Can I have one moment, please?
Sure.
Nothing further. Thank you, ma'am.
Thank you.
Any cross-examination, please? Go ahead.
Do you need these, Tim? You may approach the exhibits.
Yes, will you give them to Sheriff, please?
Good afternoon.
Hi.
You are definitely in a different spot with a prosecutor cross-examining you, huh?
Well, I've had it happen before, obviously, but what's different is being in front of a jury.
Got it. All right. So I have a couple of questions. Is it correct that you're here this afternoon kind of as a blind expert?
Yes, exactly.
Right. So you did not read any discovery of this case?
No, I know almost nothing about this case other than really Ms. Devereaux's client's name.
Okay. You never spoke to any police, correct?
Nope,
No prosecutors, correct?
no. Except in the hallway, I spoke with your colleague there.
Okay. All right. You never undertook any examination of the facts or things of that nature?
No,
You're just talking kind of in general terms, right?
yes,
All right. So you've practiced for a long time, since 1992, right?
yes,
And you've had, when we talk about the plea bargain, right, you've done a lot of plea bargains?
thousands, yeah.
All right. And in that particular situation, that's where you get the benefit for your client, right?
Right,
So if I were able to explain the process, your client comes to you and wants to be represented, correct?
yes,
The case is assigned to, we'll use myself as the prosecutor.
okay,
We both get discovery. We read that, correct?
yes,
And then at some point, one of two things could happen. You would either reach out to me and ask for a plea bargain or an offer, let me put you that way, or I would just take it upon myself and send you an offer. Fair?
yes,
Then there's a bit of negotiation that goes on, right?
right,
And everything depends on the particular facts of that case, right?
usually,
Okay. You indicated that if, that's a lot of people, that you've represented over 3,000?
definitely, yeah,
All right. Would you agree with me then that no two defendants are the same?
yes,
That no two cases are the same?
true,
That no two fact patterns or circumstances are the same?
that's true,
All right. And when you have these clients, you indicated that you have had clients that proffered before.
yes.
Can you give us a ballpark figure about how many? Are you counting in your head?
Over, not 100,
Okay.
definitely, you know, I would say it's in the tens.
Okay.
Tens of cases.
Fair enough. So maybe we'll go more than 50, less than 100.
50 might be right. I honestly did not count it up.
Okay. But it's
And I'm not sure I could even remember some of them.
sure. It's a process though, right?
Yes.
Now, do you recall in those situations, if some of them that you can recall, were you the one that reached out to the prosecution?
It can go either way. In the past, I've done both. If I can use an example.
Of course.
I recently, in fact, well, you'll see in those exhibits, there was a situation that I had where my client was charged with a drug case, and he proffered because he had been an eyewitness to a first-degree murder. So it was a little bit unusual. My prosecutor didn't know about my client's role in the murder, but my client said, I want to get a better deal than I'm going to get just on the drug situation, and here's I've got information about this murder case.
Now, was that in regards to the federal example you gave or the state example?
The state example, it was actually a federal case that the federal prosecutor and the state prosecutor worked together. My client got his deal, and he testified in a state murder case.
So I want to go over that and see if I follow you on it. You had a client who was charged with a drug case
Yes.
in federal court.
Yes,
And as we know, this is not a federal court.
right,
We know this is a state court.
right,
But we also know that the sentencing ranges in a federal court can be significant.
right. That's,
So your client wanted to give particular information to, I'm assuming, either the Denver DA's office or the Denver Police Department,
yes, both,
okay, about a homicide,
yes,
in exchange for that working its way back up to the federal level for a benefit.
yeah, the federal prosecutor reached out to the state prosecutor. My client, I was talking about the mandatory minimums in drug cases a little earlier. My client didn't want that mandatory minimum, so our federal prosecutor, and this is pretty unusual, but agreed to give my client the benefit of rolling, testifying in the state case. So he testified in the state case, got the benefit in the federal case.
All right? And in the state case, it was about, he was an eyewitness to a murder.
Yes,
So he was there,
yes, he was,
saw it,
yes,
okay, provided that information to the Denver District Attorney's Office,
yes,
and then ended up testifying for them
yes.
in exchange for the plea bargain up there.
Yeah.
Now, the federal proffer letter that you sent, was there any deal or offer made prior to this agreement to proffer or testify?
Is that the
Let's see.
same case? Well, let me, maybe I wasn't clear when I explained it earlier. In federal court, there's a specific range that you're going to get every time you successfully proffer. So in other words, depending on what the prosecution thinks is the benefit of your testimony, you'll get a benefit on your sentence anywhere from 10 to 50% off. So I've got a client who's looking at a 20-year mandatory minimum. The federal prosecutor reached out to me recently and said, if your client proffers, I'd go as high as 50. Honestly, it never usually goes that high, so I'm like, I should probably jump on that.
Okay, so that's, again, the federal range,
Right,
but in the, go ahead.
I'm sorry, I didn't mean to interrupt you. My point is that in federal court, everybody knows these rules. So you know, if you're going into federal court and you proffer, you're going to get 10 to 50% off. Usually it's about 30, you know, but, and that's really the difference. There's specific Justice Department memos about it.
Okay. But let's, if we can, but that's not the same situation in the state's courts, correct?
Right.
All right, so I want to kind of focus on that with the proffer letter that you received from the Second Judicial District
Denver.
in Denver in that office. There's nowhere in there anything about a guarantee, a promise of any type of potential offer prior to being given the information, correct?
Right, that was the case where the client was getting the benefit in federal court, so I already knew that he was going to get 10 to 40% off.
Okay, so in other cases where you've done a proffer and you don't have that necessarily the benefit with the Big Brother Federal, are you ever guaranteed anything or given an offer written up before you give the information?
Sometimes, usually what it is, hey, like I was saying before, okay, if your client proffers, I'll consider an F2 or 30 years. I keep going back to those numbers for some reason, but I personally would not walk my client in without having an idea of what kind of benefit they were going to get. I mean, if you have somebody come in on a, for example, confessing to a murder case kind of thing, this is where I buried the body, and this is what so-and-so did, this is the whole story. You make your offer, then you walk out of the proffer and the prosecutor says, okay, I'll give you a stip to 48 years. That might not be what you wanted. You might have been hoping for a 10 to 32 year sentence. And so ahead of time, you need to work that out with the prosecutor. You know, hey, I want an F3, I want whatever, and this is what I'm going to give you. If you walk in blind, the problem with walking in blind is not just that you don't have any guarantee for your client, it's also that the client is way more motivated to be not quite as scrupulously honest in the proffer, because they want, if they don't know what they're possibly going to get, it's just held in, out there like a carrot dangling in front of them for months and months and months. And so they just want to keep the prosecutor happy. They want their story to be whatever the prosecutor wants to hear so that they get the most benefit possible. They want to make sure that they give the government, the prosecutor, what they want, whether that's convicting another co-defendant, whether it's, finding other people who may have been involved in the case, whatever that motivation is.
All right. Well, thank you for that lengthy explanation. I appreciate that. And not to be mean, I respectfully disagree.
Okay.
Let me ask you this. Have you ever bought a house sight unseen?
No.
Have you ever bought a car sight unseen?
No.
Have you ever made any significant purchases of anything in material value that you have not seen?
Well, I just had to buy a new washer and dryer, and I did not see it in person before I clicked.
Clicked buy.
And Home Depot, I'm expecting it to look like it looked on the Home Depot website.
On the website, right, but you actually saw a picture of it?
Yes.
Okay, so you knew what was supposed to come. Obviously, if it doesn't come correctly, you're going to send it back, correct?
Yes.
All right, so let me ask this. Why would a prosecutor make an offer and pay for something, so to speak, before he knew what the goods were?
Well, it's not necessarily I'm sorry, my watch is, I hate these newfangled watches because they ring all the time.
It's all right.
So the prosecutor isn't necessarily going to say, absolutely, no matter what kind of crap your client comes out with, I'm giving them an F2. So there is a certain amount of leeway. There's a certain amount of play, and there is always, again, this is why a proffer is so nerve-wracking for a defense lawyer. You always have to have a certain level of trust that the prosecutor is going to give you the value of your client's story. The value you place on it may not be the same as the value the prosecutor places on it. That's why I like to have everything written down.
Well, all right, written down is usually the proffer letter that you and your client would review and sign, correct?
Yeah.
And it's usually signed by the prosecution, correct?
Yes.
And again, we have to know the facts and circumstances of the particular case that we're dealing with as to what information may or may not be appropriate, correct?
Right. For example, like in that case I was talking about with the federal state thing, I told them, hey, my client saw a murder. So they knew that's where it was headed. That had to happen because they needed to reach out to the state prosecutor.
Don't you think that a prosecutor would be committing some form of either malpractice or ethical violation if you came to me and said, I have a client, but I'm not going to tell you what he's going to say, but I want an offer, and I say, sure, I'll give you a Class F6 felony off of the Class 2 felony.
I would love that.
I'm sure you would, but that's not appropriate from the other side of things, correct?
Well, prosecutorial ethics and defense ethics are very different. The prosecution's duty is to do justice. The defense lawyer's duty is to do whatever they can to zealously advocate for that one client. So, in other words, the prosecutor can always say, I don't like I'm not gonna go through with this.
But
But could you repeat the last thing, because I wanted to
yes,
say something?
you're not going to buy something you haven't seen. Why would a prosecutor go in, and if I'm just sitting in my office and you call me up and say, hey, my client wants to tell X amount of info, or has information on this case that you're handling, but I'm not going to tell you any more about it until you tell me what kind of offer you're going to give. Why would I do that?
Well, and usually what you do is you're like, my client will tell you what the co-defendant did, or what my client will give you access to their, whatever it is. Usually you've got, sometimes this is in writing in the proffer letter, and I have seen this and done this before, where you as the lawyer write up a little summary. My client saw a guy named Joe shoot somebody at 14th and Kalamath on December 10th, 2020, or whatever it is. So you're not going in totally blind. You have some idea of what you're getting.
Okay.
And then you work on, there's always going to be back and forth plea negotiation usually.
All right. So before we get to that, I want to show you what's been entered as People's 217. Have you take a look at that for a minute, please?
Okay. Do you want me to read the whole thing thoroughly, or?
Well, I assume you know what that is.
Well, I do, yeah.
Okay, that is what we would call a proffer letter. Is that correct?
Yes.
All I want you to note in there is if you see anywhere in there where there's any type of offer that has been made to that individual.
No, I don't see that.
Okay. And would you also agree that that is consistent with the example that you provided? And I apologize, I don't know which one, but the second judicial district proffer letter that counsel entered into evidence as well.
Yeah, you don't necessarily. So when I was mentioning, sometimes you put it in the proffer letter, sometimes you don't.
Okay. So you're familiar with the term COCA?
Yes.
Okay. And COCAs are usually large, organized crime-type prosecutions that involve a lot of people.
Yes, they're frequently a good proffer situation.
Okay. And you'd agree with me that a lot of those types of situations, the attorneys, defense attorneys, would go to the state and seek to proffer because they can maybe get better evidence against somebody higher up on the ladder or even below the ladder. Fair?
Yes, that does happen.
And in those types of situations, the same type of proffer letter is given out because nobody's going to buy anything or sell anything until they get the information to evaluate it. Is that fair?
I don't know if it's the same. I would assume it is.
Okay.
But I don't know I haven't looked at every single person's.
My point is that before any type of discussion about an offer after a proffer would have to be because you've had an opportunity as a prosecutor to evaluate the information compared to the discovery that's been provided and make the determination if that person is telling the truth, right? You corroborate things, you verify, that type of stuff. And if that's the case, then you can begin the negotiations. Is that fair?
That may be how you look at it. To be honest, I have not worked for a prosecutor's office since I was in law school, so I don't know exactly how prosecutors do it, but I would assume that it's some similar.
Okay.
You look at the case and you're like, I've got a hole here, and you say to the defense lawyer, if your client is willing to tell me about who he got the drugs from.
Okay. So you've practiced extensively is it Boulder or the metro area, or where do you practice?
I practice all over the state pretty much, but mostly the metro area and on the western slope.
So do you practice very often up here in Weld County?
No.
All right. Do you think it's a little, and again, I'm not trying to be demeaning. I mean, do you think it's a little broad to accuse defense bar in a certain jurisdiction of being incompetent because they don't do that? Because I'll tell you, that's not how it works up here.
Objection, he's testifying.
I'll sustain the
Okay.
objection.
Would you be surprised to know that doesn't happen up here in Weld County?
Well, I have heard that in Weld County, because I also communicate with a lot of other people. My best friend practices in Weld County. My husband was a public defender here. So I have heard that going in and giving your statement to the prosecutor is a practice in Weld County.
All right. And you indicated that you had a tenure in Adams County for
I did,
5 years?
5
All right.
years.
I actually prosecuted in Adams County for 17.
Oh,
And I never, no proffer of that, no offer was ever made pre-proffer. Was
Okay,
that ever
that
happened?
wasn't the case when I was there, but we used to have to go, if, like on a murder case, we'd have to go to the head DA.
In terms of a proffer? Or are you talking in terms of a plea bargain?
Plea bargain on a murder case or something
All right,
similar.
right. In regards to, if you had an individual charged with murder at the public defender's office in Adams, and there was some negotiations going on about a potential resolution of that case, not a proffer, so the jury understands, you would have to go and communicate with the elected district attorney at the time
Right,
and get his
that was the
blessing out.
rule there.
That was the rule. That would be Mr. Robert Grant.
It was, Bob.
Okay,
I will sustain the objection.
very good. So same with Jeffco. Do you practice in Jeffco
I
then?
do.
All right.
I haven't in the past couple years, but I have done cases there.
And I did as well, and in Jefferson County.
And Mr. McCormick,
Okay.
just-
Well, I'm trying to get out the fact that there are multiple jurisdictions where this does not happen. If the court's preventing me from going into that, I will move on.
so if the parties will approach it.
Let me rephrase that. You practice in Jefferson County,
Yes,
and are you aware if in Jefferson County they ever gave you or a client an offer before the proffer?
that did happen in one of my murder cases.
Okay. And what, did that individual then give a proffer?
Yes,
right.
with actually a lie detector.
Okay. So I want to conclude here because in your, well, you bring up a great point. You said a lie detector test, right? Or, yeah, I forgot what they're called, but lie detector
I do
test,
too.
okay. All right. But I mean, again, it's a pretty bold statement to say that somebody's incompetent to have their client go in and provide information without the benefit of an offer. And that's what you're saying, right?
Well, if you don't know you're getting an offer, yeah.
Okay. You're kind of, like you said, I think you said in your report, it's kind of dangling the carrot out there.
Right.
You want to have that information and then we can determine an offer, right?
Okay, could you repeat that one? 'Cause
Sure.
I didn't.
Let me boil it down to this. Two things. Do you know Keith Coleman?
I do. I
Okay.
actually practiced with him in Adams County.
Do you know that Mr. Coleman was a attorney assigned to the co-defendant in this case?
I did know that.
Okay, and Mr. Coleman and his co-counsel, Ms. Lilly, were the ones that approached the district attorney's office about doing a proffer,
Okay,
okay? And that no offer was made pre-proffer, and only after the proffer was done were negotiations begun. Does that make Mr. Coleman or Ms. Lilly incompetent?
no, what it means is that they have, I'm assuming this is you we're talking about. You're the prosecutor?
Well,
I mean,
Two of us, yes.
your team,
our team,
the only way you could be competent and do that is if you implicitly trust the prosecutor on the other side.
well, I would assume if the defense attorney didn't trust the prosecutor, he'd probably,
Testifying, Your Honor.
That I'll allow that question.
I would assume that if the defense attorney didn't trust the prosecutor, then there probably wouldn't be that conversation.
If they didn't trust the prosecutor,
Correct?
I would just say no. I've done it.
All right. I don't have any further questions. Thank you.
All right, thank you. Any redirect examination?
Very briefly.
Okay.
Thank you.
Okay, Ms. Mulligan. So we've talked a lot about situations where co-defendants, one proffers on the other. Does that frequently happen in a homicide case? Is that the type of serious case that would happen?
Yes.
And if that happens and the co-defendant proffers, the interview is done, and then that co-defendant, that person who proffered, gets let's say a stipulated sentence of 16 to 32 years down from a homicide. Is that a benefit, ma'am?
Incredible. That's a great offer. I mean, on a first-degree murder. The real problem, and I want to make sure I'm answering this clearly so that I can explain it in a way that if it's like I said before, if you don't know what the offer is going to be, the motivation is there to tailor the story to what this other side wants, even more than already the motivation is to give them what they want, to get a better deal. The longer that stretches out, if you don't know, over time, you are just going to be putting your client in a situation where they're constantly trying to make sure that their statement conforms to what the prosecutor's ultimately going to want them to say at trial or wherever.
And this sort of like dangling of the carrot, I think you called it. Have you seen a proffer agreement where, say, a person proffers, they get the plea deal, and then within the plea deal, there's an agreement for what's called a 35B, a motion for reducing the sentence if they can testify truthfully, according to what the prosecution believes anyways, after the trial is done, that they proffered on?
Yeah, I've seen that in federal court.
Okay. And is that more of this, again, dangling of the carrot over this person's head?
Yeah, obviously.
Okay.
Because the benefit to the client is in the future and it's amorphous. A 35B is one of those things where, okay, you get 30 years, a 35B is a sentence reduction. It could be 10 years, it could be 20, you could walk out next week. It just, the better your story, the better you're going to be.
And Mr. McCormick was asking you, and you were testifying about this, like, need to trust the district attorney unless the proffer agreement specifically written out, right?
I just want to, it doesn't have to be written out in the proffer agreement. There has to be an understanding.
Okay, thank you for that clarification. Could you see a situation where a defense attorney who used to work with the same prosecutor would be that kind of scenario where there was a trusting relationship?
Yeah, I mean, if you're friends with the prosecutor, you're obviously going to trust that person to give you a deal, give you the deal you want, much more than if it's somebody who you've never worked with or against before.
And then Mr. McCormick asked you about Keith Coleman.
Yes, I do know Keith.
Okay. Have you recently read a transcript where Mr. Coleman was sort of on this side of things?
Yes.
And was he essentially on the side of things of arguing that the person who proffered against his client got a benefit as well?
Right.
And that was his basis for testifying as well?
Yes.
Nothing further. Thank you, ma'am.
All right, thank you. Ms. Mulligan, you can leave the witness then. Thank you, ma'am.
Thank you, Your Honor.
The defense may call their next witness.
Your Honor, the defense calls Sarah Erfer.
Sarah Erfer, all right, thank you. Thank you. Ms. Erfer, if you can come forward and just stand in front of the witness stand for me. All right, thank you. And ma'am, can you please raise your hand for me? Do you swear or affirm under penalty of perjury that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth? Yes. All right, thank you, Ms. Erfer. And Ms. Erfer, can you get just as close to the microphone as is reasonable so we have a good record? And Ms. Trujillo, you may begin when you're ready.
Thank you. Good afternoon, Ms. Urfer.
Good afternoon.
Could you please just introduce yourself to the jury and spell your last name?
It's Sarah Urfer, S-A-R-A-H, U-R-F-E-R.
Thank you. And Ms. Urfer, where do you currently work?
Chemitox Consulting,
And what is that?
forensic consulting company.
What do you do for them?
I'm a forensic toxicologist.
All right. And exactly what does a toxicologist do?
Toxicology is the study of the effects of poisons, which includes drugs and alcohol, on the human body.
And you said forensic. What does the forensic part mean in regard to toxicology?
Forensic toxicology is applying that field to the law. So forensics just means an application to the law.
And you may have stated this, and I apologize. Your role at Chemitox is the chief forensic toxicologist, right?
Yes.
Okay. Did you have prior roles with Chemitox?
Yes.
And what were those?
Until 2019, we ran a laboratory, and so I was also the laboratory director for Chemitox. The state decided to offer the same services as us, but for free, and I could not compete with free, so we had to close the lab portion, and now I just do consulting.
Speaking of for free, you are testifying. Are you getting paid for your testimony?
No, I'm getting paid for my time.
Yes, okay. So your time, does that include time that you could be testifying?
Yes.
Does it include time if you've like written a report or any work you've done?
Yes, and travel.
Does the fact that you are getting paid for your time influence the way that you are testifying?
No, it does not.
So chief forensic toxicologist at Chemitox, are you board certified in any way?
I am.
What is that?
So I sat my board exams for the American Board of Forensic Toxicology. It is both an experience and education-based board exam, and then I do continuing education every year in order to maintain my board certification.
Okay. And prior, I suppose, do you have specific types of education or degrees that qualify you to be a toxicologist?
Yes, I have an undergraduate degree from CU Boulder in biochemistry. My minor was in chemistry. I have my master's degree from the University of Illinois in Chicago in forensic science. My emphasis was in toxicology and drug chemistry. And I did my internship with the Illinois State Police Forensic Science Center of Chicago, again in toxicology and drug chemistry.
Have you published within the field of toxicology?
Yes.
Do you publish often within the field of toxicology?
I try not to.
Do you also present within the field of toxicology as a toxicologist?
Yes, that I do as much as I can.
Okay, a little bit more fun than publishing?
Much more interesting.
Have you presented on toxicology for the criminal defense bar in Colorado?
Yes.
Have you presented generally for the Colorado Bar Association?
Yes.
As well as district attorney's offices?
Yes.
And have you presented for police departments?
Yes.
You mentioned in regard to your board certification that you do the continuing education once a year.
Yes.
Do you do other kind of continuing education in addition to that?
So I do between 20 and 40 hours of continuing education a year, which is more than is required for my board certification. I also stay up to date on the current literature because there's always evolving science coming out as part of that.
Okay. And are you part of any kind of professional organizations related to toxicology?
Yes.
Could you please share those with the jury?
I am a member of the American Academy of Forensic Sciences Toxicology Division, the Society of Forensic Toxicologists, the International Association of Forensic Toxicologists. I am also on the committee for the National Safety Council Drugs and Impairment Division, THC Safety Committee. I was the founding chair, and now I just sit on the committee.
Okay. Ms. Urfer, have you been qualified as an expert in toxicology before?
Yes.
About how many times, if you had to throw a number on there?
Over 550.
Your Honor, at this point, we would move to tender Ms. Urfer as an expert in toxicology pursuant to 702.
Any objection?
No, Your Honor.
All right, the court will accept the witness as an expert in the proffered fields, and Mr. Heel, you may proceed accordingly.
Thank you. Ms. Urfer, I want to start generally discussing alcohol. You said that the forensic toxicology or toxicology in general involves poisons in the body.
Yes.
Alcohol being one of those.
Yes, and for clarity, when we talk about alcohol, I will be talking about ethyl alcohol or drinking alcohol, and I'll just refer to it as alcohol for short.
Thank you for that clarification. Is that type of alcohol a central nervous system depressant?
Yes.
What does that mean?
So your central nervous system is your brain and your spinal cord, and CNS depressants are drugs that slow that system down and impact its ability to function.
Yes. Is it possible to measure the amount of alcohol or drinking alcohol that a person might have in their system?
Yes, you can measure it in blood or breath if you want to know what is actively impacting an individual.
If this was mentioned or measured in blood, would that be blood alcohol concentration?
Yes.
Or what we would maybe know as BAC?
Yes.
Okay. Now, does the level of alcohol then suggest certain effects it might have on the person?
So in general, alcohol is going to have a profile of effects that scales with concentration in humans. There is some variation in what exactly that's going to look like between individuals. But if a human being ingests a CNS depressant, there are going to be some effects that are consistent along that spectrum between people.
Okay. I want to talk about that spectrum and the different stages. When we're talking about levels of intoxication generally, in your practice, is there usually 7 kind of stages that you might look at if we're looking at the BAC correlating to symptoms?
Well, there is a specific publication that breaks it down into 7 stages. It's called the Dubowski chart, and it's just a nice summary for purposes of understanding how the concentration and effect relate to each other.
Okay. I want to just talk generally. We don't have the physical chart in front of us, but I just kind of want to go through those stages for the jury.
If you want me to recite all of the numbers and names, I will need to get my copy out to refresh my memory.
No problem. Let's try, and we can just see.
Sure.
Okay. Does it sound right that these stages specifically are designated by a range of blood alcohol concentration?
Yes, so the way the chart's set up is that there's, starts with subclinical and goes all the way through coma and death as, a range of possible effects, has a range of blood alcohol concentrations associated with each of those. Those concentrations do overlap because we have to account for variation between individuals. And then there's a brief summary of some of the most common clinical effects that can occur with each of those levels.
Okay. You just mentioned subclinical, so let's start there. Does subclinical include the BAC from 0.01 to 0.05?
Yes.
And I guess just for comparison purposes, generally, if we're talking about somebody driving under the influence or like the legal definition of that, do we normally look at 0.08 in your experience?
Well, 0.08 and 0.05.
Okay, yes, for the driving while ability impaired?
Yes.
And then the driving under the influence is the 0.08?
Correct.
Okay. So we have that subclinical stage, and then we move into the euphoria stage?
Yes.
Is the euphoria stage BAC about 0.03 to 0.12?
If you are operating off of my summary, then yes.
Okay, I am.
Good.
Is the third stage then the excitement stage?
Yes.
Does that include BAC from 0.09 to 0.25?
Yes.
And then do we have the confusion stage?
Yes.
Does that include BAC of 0.18 to 0.30?
Yes.
And then we have the stupor stage, is that correct?
Yes.
And is that including BAC of 0.25 to 0.4?
Yes.
And then do we move along to what might be considered a coma stage?
Yes.
Does that include BAC from 0.35 to 0.5?
Yes.
And then finally, and you had mentioned this, we have these different stages, and then ultimately do we get to a stage where we think death might be likely?
Yes.
Based on the, too much alcohol in the system?
Yes, alcohol poisoning can lead to death. It is a poison in the human body.
When we're at that stage, are we talking about BAC that's around the 0.45 mark?
Yes, potentially. I've seen people dead at lower levels, and I've seen people driving at higher levels, but as an average, when you take a normal drinker above that level, you risk death.
Is this kind of why you consider it to be the spectrum?
Yes.
Is it fair to say it's a spectrum because every individual might have, alcohol might affect them differently?
Within a range, again. I mean, if somebody drinks alcohol, they're going to get intoxicated to some degree. They will fall onto that spectrum. But heavy daily users are going to have tolerance to at least some of the side effects, and so those side effects won't be as pronounced. And that includes keeping them alive. It does damage to their liver long term, but their body does produce a huge amount of enzymes to try to break that alcohol down as effectively a self-defense mechanism from daily use. And so that's part of why these ranges overlap. It's part of why there has to be some variation. But a human being who ingests a CNS depressant will have some effects from it. The exact degree of those effects is what's going to vary.
Okay. You mentioned, the heavy daily users will have a tolerance and it could damage their liver.
Among other things, yes.
Okay. If we're thinking of just the liver, in your experience, if somebody is a heavy drinker or if they drink and stop drinking and drink again, does the liver try to rejuvenate itself?
Your body is always trying to heal itself as a general rule, barring severe medical conditions.
Okay. I want to just kind of maybe clarify the different overlapping when we have these different stages. So if we're looking, I want to start with the confusion stage and the stupor stage. I'm not sure if it might be helpful for the jury. Would you mind writing the confusion and the stupor stage, the ranges on that board? I can get you a marker. Your Honor, could I borrow a marker or approach?
Yes,
I think
do
there's
we
some
have,
right there.
I don't know where they're at, but there's some.
I can use these.
If you would like to give me what you want me to put up, I'm happy to do so.
Thank you. So if we're looking at the confusion stage, if we could write confusion stage up on that board, please. And is the confusion stage we've talked about is the 0.18 to 0.3, right?
Yes.
Okay.
And Ms. Zerfer, at any time, if it's necessary to refer to your scholarly materials, just let us know.
And then the stupor stage we have from 0.25 to 0.4. Okay, thank you. This should be all for the board. If you could just explain to the jury, I see that you put the BAC grams for the milliliters. Can you please explain what that measurement is?
Yes. So if you take a blood sample from somebody and you test it for blood alcohol concentration, then for at least forensic purposes, we generally measure that as grams of ethyl alcohol per deciliter of blood, or 100 milliliters of blood.
Thank you. So we're looking at this, we can kind of see the confusion. Does the confusion end at the 0.3 and does the stupor start at 0.25?
What this is demonstrating is that it is a spectrum. So depending on the individual, depending on their tolerance, if say they're a 0.26, right, they could be exhibiting some signs and symptoms from the confusion stage and some signs and symptoms from the stupor stage, depending on their own personal reaction to alcohol, their drinking history, things like that.
Okay, thank you. You had just mentioned prior to writing this out that you've seen individuals have a lethal dose or a lethal BAC lower than the 0.45. Was that correct?
I had a 16-year-old who passed away at a blood alcohol around a 0.2.
Okay. And you've said that you've also seen people that I would imagine driving, is this a DUI investigation, that you've seen people driving with higher alcohol concentrations?
Driving and suicide cases,
okay.
Where we've seen blood alcohol levels considerably higher. I had a very sad case of suicide of a gentleman whose BAC was a 0.628. But he shot himself. So alcohol poisoning is not what killed him.
sorry to hear that.
It's a very sad case.
Okay. I want to talk about some of these general symptoms that we may see. Is it fair to say in all of these 7 different stages, there are general symptoms, but once again, depends on the person, like you had just, essentially explained?
Correct.
Okay. So I'd like to start with the excitement stage, and as the court said, if you need to refer to your materials, just let me know, please.
Thank you.
Okay. So with the excitement stage, we're starting from the 0.09 to the 0.25. Possible symptoms, do these include emotional instability?
Yes.
Impaired perception and memory?
Yes.
Poor comprehension?
Yes.
It could be increased reaction time?
Right, meaning that they don't react as fast as they normally would.
Impaired balance?
Yes.
Is slurred speech something you might see?
It's potential, yes.
As well as potential for vomiting or drowsiness?
Correct.
The confusion stage, so kind of where we're talking about this 0.18 to 0.3, this could be, in addition to maybe some emotional instability, exaggerated emotional states?
Yes.
Disturbances of vision?
Yes.
And when we're in this confusion stage, is another possible symptom that you might expect somebody to show would be like an increased pain threshold?
Yes, alcohol does act as a painkiller at high enough concentrations.
Similar to what we had talked about with the reaction time, but in this kind of confusion area, we might have more issues with like incoordination of muscles.
Correct. Hand-eye coordination, balance, and actually slurred speech is related to that muscle coordination, the tongue being a muscle, difficulty with enunciation and speech.
And then we get to the stupor stage. And there again, we have the BAC of the 0.25 to the 0.4. Is a possible symptom, difficulty standing and walking?
Yes.
Issues with the motor functions?
Correct.
And when we talk about motor functions, what do you mean?
Again, it's like hand-eye coordination, ability to walk, stand, balance, control your body in a way that it responds as you expect it to.
And is there a possibility that when we're in this stupor stage that it could be impairing somebody's consciousness?
Yes.
And is that because of the level of the alcohol in their system?
Yeah, I mean, assuming that the stupor is caused by alcohol, then yes.
Yes, okay. So if the stupor is caused by alcohol and we're looking at this range that's, much over the 0.08 kind of limit, is it fair to say that these types of issues with consciousness, motor functions, ability to like stand and balance is only gonna perhaps get worse?
As for any given individual, as their blood alcohol concentration goes up, their symptoms of intoxication will increase as the alcohol level increases.
Okay. You have stated that, again, it depends on the person.
It does.
So does it depend, not only on that one individual compared to another individual, but their actual drinking habits?
Yes, and not just their drinking habits, but their drinking that day. The most classic example of this would be if you have the same individual drink the same amount of alcohol, but one day they drink that amount of alcohol over, say, like a 5-hour period, and the next day they drink the same amount of alcohol, but over a 1-hour period, you're potentially going to see different impact from that because the rapid drinking in a short period of time will cause their blood alcohol to rise very quickly, potentially reaching a higher peak concentration than somebody drinking steadily throughout a day, say over a 5-hour period, the same amount of alcohol. So it's not just how much they drink and their own habits, but how they drank the day of the incident in question.
Does it also depend on what they were drinking?
Not as much, other than if you're drinking like 3-2 beer, you just need a lot more liquid to get to a known blood alcohol concentration. But if you're drinking Everclear, then yeah, you'll get drunk a lot faster. It will be considerably unpleasant, though.
So the alcohol concentration, say like 3.2, is just the concentration. You're going to have to drink the same amount of the fluid, if you will, or the liquid in order to get it if you were drinking a higher concentration of alcohol.
Your question does not make a lot of sense.
That's fair. 3.2 beer, you're going to have to drink a whole lot more. as if you were taking shots of a higher concentration of alcohol.
That is correct.
Okay. Thank you. You had said, talking about drinking that day, the timing of it all versus over a few hours. Is there, what would it happen, or how does kind of we talk about this tolerance if somebody is a chronic drinker, if they're drinking all the time? What does that kind of look like and how it would affect them?
So with somebody who is a chronic drinker, which is normally defined as daily or near daily use to an elevated level, again, even in that circumstance, if they drink really rapidly, they're going to have that higher blood alcohol peak than if they're drinking slowly. But that daily drinking means that their body tries to compensate for the constant presence of alcohol in the body. It does that by, I talked about earlier, the liver enzymes producing at a higher rate to try to get the alcohol back out of their system faster. You can also see what we call functional tolerance, where they learn to over-enunciate to compensate for their slurred speech, learn to walk with their feet farther apart so that their balance isn't as bad because they have a wider base. These are all potential things that you'll see in people who drink a lot. And as a result of their body attempting to overcome some of these side effects, they may not lose consciousness as quickly as somebody who drinks less, for example. Or, some of these effects may not be as severe if they are a very heavy drinker. The overlap in this chart is to account for some of that, but there are always people who are at extremes, like the case I mentioned earlier would be a very extreme situation.
You mentioned the behavioral tolerance. This is your body attempting to overcome kind of these reactions to the alcohol. Is that fair?
So functional tolerance is you trying to overcome it consciously, and then chemical tolerance is your body trying to overcome the constant presence of the alcohol. That's the liver reactions, things like that.
Okay. If somebody is making that conscious decision, walking with a wider stance, attempting to enunciate more, does that ultimately, could that become a learned behavior?
It is a learned behavior, yes.
So if somebody was drinking, or whether or not they were a daily drinker, but drinking was a habit for them or something common, is it possible that that person doesn't have to consciously think about taking a wider step each time? It just becomes how they respond?
It can become habitual.
Okay. Can you explain the difference, or is there a difference, and I guess, with the chronic kind of drinking that we're talking about and binge drinking?
They are not mutually exclusive. Binge drinking is a reference to a specific pattern of drinking. That would be the drinking all of the alcohol in 1 hour example. It doesn't have to be 1 hour, but it's drinking multiple drinks generally to get a blood alcohol concentration at least over a 0.08 in a short period of time, an hour or two.
Is that different than from a bender?
Bender is normally a reference to somebody who is drinking in excess of their own normal for as long as they can manage to get their hands on enough alcohol to continue, which could include binge drinking. They're not exclusive from each other.
Okay. Could you binge drink for multiple days in a row, resulting in a bender?
People do, yes.
Okay. If somebody is drinking, whether this be that kind of constant exposure, or if it is binge drinking, say, one day, maybe not even the next day, is it possible that they may develop a tolerance even with that? Like if they were just binge drinking, would you get a tolerance?
Yes, people who binge drink, even if it's not necessarily every single day, as long as it's relatively frequent, will develop some alcohol tolerance. The tolerance is going to scale with the frequency of drinking.
If somebody does have this kind of elevated tolerance, they drink often, is their liver going to have a response?
I'm not a medical doctor, but from a toxicology perspective, yes, there is an impact on the liver anytime anyone drinks alcohol. Higher concentrations can result in liver toxicity.
Okay, thank you. You had mentioned a few specific examples in your experience of the really, really high BAC versus maybe what we would consider kind kind of in the middle range here, also leading, it seems like, to similar kind of outcomes for the different individuals.
Yes.
Is it possible that if somebody kind of does get this tolerance for however they may get the tolerance, that the BAC on its face may seem more alarming than the effects as how they appear?
So, I mean, I think yes is the short answer. The longer answer is we have had people driving and they're not safe, do not get me wrong, but they are operating a motor vehicle at levels that I have then seen in other cases. People are like passed out on a curb. So yes, if somebody is a more tolerant drinker, they may not come across as drunk from a casual observation as somebody who is a less tolerant drinker at the same blood alcohol concentration.
You talked about the behavioral tolerance, right? Is there something called acute tolerance?
Yes.
What is that?
Acute tolerance is just a reference to rapidly acquired tolerance from a specific drinking episode. So to some small degree, you actually develop a little bit of tolerance to alcohol just in any one drinking episode. It can be measured, but you have to do some special stuff to actually see that. But that's called acute tolerance, meaning that if you measured their intoxication and signs of impairment as their blood alcohol was rising at, say, a 0.1, just for argument's sake, and then they go above 0.1 and they're coming back down, and you measure their impairment on the way back down at 0.1, they might be slightly less impaired at a 0.1 on the way down than they were on the way up. That's acute tolerance.
Okay. So if we're looking kind of the same line of this being a spectrum, if one person, so if you're looking at an individual, you have their blood alcohol concentration, just looking at that number specifically does not tell you how they were acting.
Correct.
Possible that, if somebody's at that point, like 2.5 or 0.3 level, one person could be falling over and one person could be walking.
Correct.
You mentioned this briefly in the beginning, but I want to clarify, that if a person has that higher tolerance for however they received that tolerance or their body, developed that, will they experience likely some overall downgraded effects of the alcohol or the symptoms that are presented?
That is what tolerance is. The effects are not as strong at the same concentration as they were prior to tolerance developing.
Okay. Would you agree that if somebody is in that 0.3 or higher range, they're intoxicated?
Yes.
Okay. Doesn't matter who you are, you're drunk if your BAC is at 0.3 or higher?
Yes.
Okay. I want to talk about a specific type of symptom for alcohol intoxication. Can you kind of explain to the jury how alcohol may affect somebody's emotional state?
Yes. So in general, alcohol can cause what we call emotional instability, meaning that whatever their current emotional state is, it may be exaggerated and unstable. Sort of a classic example of this is somebody may say like, oh, they're a crying drunk or an angry drunk or a happy drunk, like their mood is amplified by the alcohol.
Okay. Of course, again, depends on the individual.
Yes.
Okay. So is it fair to say that if somebody, when we're thinking of the crying drunk, the angry drunk, whatever mood that they had at the moment, perhaps before they started drinking or when they started drinking, that mood is going to get elevated or exaggerated?
It could.
It could, depending, again, on the person.
Yes.
Okay. So if somebody, starts from a point that they're stressed or agitated or angry, those feelings could increase once they become intoxicated.
Correct.
Okay. Do you often see, or does the science kind of support the idea that it's more likely that emotional state would be exaggerated versus it not being exaggerated?
Just depends on the individual circumstances, and even the same individual could vary from drinking episode to drinking episode.
Okay. I want to kind of switch gears and talk about the post-mortem redistribution. Can you please tell the jury what that means?
Yes. So in a deceased individual, after the body has ceased to be alive, you can actually have movement of the drugs in the body. This is not because of metabolism, so because the heart's not pumping, the liver's not functioning, but they can still move around, and that movement is called postmortem redistribution, or more fully, postmortem redistribution of drugs in bodily fluids after death.
So if we're thinking of this redistribution, it's after death. If you were going to take somebody who had, or somebody that was deceased and take their blood alcohol concentration, does that kind of when this kind of issue would become relevant?
Yes.
And is it, why?
So different drugs exhibit different levels of postmortem redistribution. So some drugs are more stable than others. It's also dependent on how long the body was left. Like say at room temperature or warm. Refrigeration tends to slow. So for ease of speaking about it, PMR, postmortem redistribution is what we call it. So PMR is going to slow down with refrigeration. And so if you're trying to interpret a level, it is good to be conscious of the fact that that level might not exactly represent what was in their system at the time of death. And then in order to kind of assess how likely there is a change there, then you want to look at, like, was the body promptly refrigerated? Was there a long time where they were, say, like warm or something like that? And keep that in mind in interpretation of any given level.
If a body that you receive blood alcohol concentration from was severely decomposed, so not preserved in this kind of way that you were just talking about, does that affect maybe like the point, it's a measurement around like 0.05, if we think of it sliding, maybe their BAC scale?
In general, in particular, so this is actually not just post-mortem redistribution. For alcohol specifically, alcohol can actually be formed in the human body through fermentation after death as part of the decomposition process of the human body. And so in what we call decomp cases, you can see blood alcohols normally at most up to a 0.05 generation of alcohol that is not from them consuming alcohol, but actually from decomposition. And that's not PMR, that's decomposition of the body.
So kind of two different issues, fair to say?
Yes.
Okay. If we're thinking about the 0.05 and you're looking at somebody's blood alcohol concentration, and we're looking at maybe how they might be reacting, does that 0.05 make a huge difference for you?
I mean, it depends on what the level is.
Okay.
If their level is 0.06, yes, it matters a huge amount. But if they have an extremely elevated blood alcohol concentration, then I can still state with some certainty that they are still likely very intoxicated, but not put, an exact number on it.
Okay. With the idea of refrigeration, or you said like warm temperatures, right?
Yes.
If a body was burned before blood or urine was taken, could this affect the level of the blood alcohol concentration?
I have seen reports where there has been, say, somebody who was like at a hospital and they've taken a sample from them, and shortly after that they're in, say, a car accident where the body is burned and they get another blood alcohol from them. To the best of our ability to extrapolate from that data, it appears that in some but not all cases, you might have a change in blood alcohol concentration between the two.
Would the change be like an elevated concentration or a decreased concentration?
I've seen both reported in the literature.
Are we still within that 0.05 range?
I don't recall what the exact numbers were, but It's not astronomical. I mean, it's, I believe, always less than 0.1 at least, and probably less than 0.05.
Okay, thank you. Mr. Fair, may just have one moment. Sir, I just have a few more questions for you. You had said that the ethyl alcohol, so the drinking alcohol, can increase someone's pain tolerance.
Yes.
How does that happen? Or why?
It's affecting the central nervous system, your brain and your spinal cord, and so it can impact your ability to perceive pain.
Okay. Is this consistent with the idea of what we've been talking about of you move up, or I guess up or down this chart, your BAC is increasing, those types of, the pain tolerance, all those kinds of symptoms are also going to increase or have more of an effect?
Yes, so all of the effects are going to scale in any given individual. With increased levels of intoxication, you have an increased possible effect. Lower levels of intoxication, lower effect.
Okay, great. Thank you, Ms. Erford. Nothing further.
All right, thank you. Any cross-examination, please? Go ahead.
Hi, ma'am.
Hello.
Good to see you again.
You too?
3 weeks ago.
It's been a short period of time. Yeah, I don't remember the date, but
Same courtroom.
right. We're here again.
All right. Ma'am, you had referenced this Dabowski chart in general. That's what your letter is completely based on. Is that fair to say?
When I am referencing these levels, that is the reference that I use, yes.
Okay. And to be clear, within that chart, you have made it pretty clear that they're overlapping ranges and it depends on the person.
Yes.
Okay. As it depends on the person, unless you would know them and study them, you're not going to say.
Right. Again, you can give ranges, you can give general statements, you can give ideas, you can have things supported by observation, but I can't say, oh, you had this BAC, here is a checklist of exactly how you were behaving.
Right. And unless you were doing some clinical observation like that, to be clear, in this case, you weren't provided any of the facts.
Right. I am testifying as a blind expert.
Okay. And just explain what that means.
What you just said. It means I was given none of the facts. I am testifying purely as an informational expert on my area of expertise, not specific to any given fact in this case.
Okay. So I just want to go through a few of those ranges that were touched on, a few of those that were written down, and some that were not, okay?
Yes.
Even in the 0.09 to 0.25, that's the excitement stage. Fair to say that Kurt Dabowski discusses sensory motor incoordination.
Yes.
And impaired balance.
Yes.
Okay.
If I can get out my chart, if we're going to keep going through this, that would be lovely. Is that okay?
Feel free, ma'am.
Thank you.
Yeah.
Got it?
One moment.
Okay.
Computers. Had to log back in. Okay, now I'm ready.
All right. And I just want to approach to make sure I'm looking at the same thing you would be, ma'am.
Scroll to the bottom.
That would be it, Mr. Dabowski, right?
Yep.
Or
Yes.
Dr.
Dabowski.
Dr. Dabowski. All right, so let's go through some of these that Dr. Dabowski noted. In that excitement stage that we discussed, it's towards the bottom of that section, sensory motor incoordination and impaired balance.
Yes,
In general,
in general.
okay. And then we go down to the confusion stage, and that would be increased muscular incoordination.
As one of them, yes.
Describe it.
So muscular incoordination, so this would be somebody who's, you know, maybe trying to reach this way to, you know, to their left and reaches to their right instead, or, you know, can't grab something or is struggling to coordinate their body.
Okay. And then it goes further, staggering gait.
Yes.
Explain.
So that's the stumbling or staggering, so inability to stay upright, potentially falling, having difficulty maintaining their balance.
So this person, just in that stage, based on what you're describing, is about to fall down on their own and, or close to.
They may be, yes.
Maybe. Again, varies each person. We'll
Yes.
give that disclaimer throughout this. I won't go over that each time.
Yes.
Then we get into ataxia. Is that a neurological condition, ma'am?
Again, I'm not a doctor, but yes, it's heart and neurological issues.
Okay. But is it fair to say that ataxia is a neurological condition characterized by a lack of muscle coordination and balance?
Right.
Okay. It can manifest itself as uncoordinated movements such as clumsy walking or difficulty with fine motor skills.
Yes.
Okay. Also dealt with slurred speech, as you talked about, would be a motor function. Fair?
That's correct.
And then going down underneath that threshold, there was the stupor, and that was written up on there without any of the aspects that are contained in it, but that would include general inertia.
Yes.
Would that be a significant decrease in physical movement and responsiveness?
Yes.
So can you give an example of what that general inertia might look like?
So just in general, when we talk about the stupor stage, you're normally talking about what a lot of people think of when they think of alcohol poisoning, which is that they're conscious normally and awake, but not reacting to like verbal communication, not able to control their body, frequently not able to stand up. And that's why it's called stupor.
Okay. I mean, pretty obvious.
It is in the name.
Okay. And then it goes on to say approaching loss of motor functions.
Yes.
Is that what it sounds like?
Yes.
Okay. And then what's next?
Let's see. Marked decreased response to stimuli, marked muscle incoordination, ability to stand or walk.
Yeah, tell us what that response, markedly decreased response to stimuli, what would that look like?
That's the not responding to somebody like saying your name, trying to talk to you, trying to get an answer from you, for example.
And then let's focus on the marked muscular incoordination, inability to stand or walk.
Yes.
Fair? Do we need a definition of that?
I think it is in the name.
Okay. And again, those are just dealing with those ranges that we've gone through. Now, excitement wasn't on there, but then confusion and stupor.
Right.
Okay? And the ranges were contained on there.
Yes.
So I also want to ask about, you reference back to CNS depressant. You said it multiple times.
Yes.
What is CNS?
Central nervous system.
What does it do?
It's your brain and your spinal cord. So it is the thing that controls your body
Okay.
from a neurological perspective.
And what is ethyl alcohol?
It is a CNS depressant.
And therefore, how do they interact?
It slows down your brain and your spinal cord, slows down muscle coordination, mental ability to process, vision, many, many things.
Okay. And so based on all of those factors that we went through, the higher the VAC, the worse motor function, coordination, decrease in balance, all of that exists, right?
Right.
And because it's impacting that central nervous system, is it fair to say that if an individual has a massive physical impact on them when they're already in one of those levels, such as like, let's take a car accident for a moment. Let's say a person's driving and they're at a high BAC and they hit something and their head hits the steering wheel.
Sure.
Is that person more likely to pass out than somebody that's not at that level of intoxication?
So again, I'm not a medical doctor, not trying to diagnose people. In general, what I have seen in the research is that individuals who have a drug impacting their central nervous system who then sustain a central nervous system injury are more likely to have severe outcomes from that injury because of the co-impact of both the injury and the drug that's impacting that system at the same time.
And that could include unconsciousness, temporary, right?
Yes.
Okay. And so if a person was going through a situation and there is a heavy physical impact on them, that could, because they're already dealing with the CNS depressant that's in their body, that could be enough to make that person pass out, whereas it wouldn't a sober person. Fair?
Potentially.
Okay. As it pertains to this absorption rate?
Absorption, yes.
Okay. You had discussed this suicide, tragic case.
Yes.
.628. Talk about the process before we get into that. Does there have to be some period of time to actually get into the blood system?
Now would be an opportune moment for me to draw another picture, if that's okay. Anybody? Okay. Is that a yes, it's okay?
If you really need to, ma'am.
It would help.
Go ahead.
Sit back down so that I'm on the microphone here. All right, so my rough little chart here. This is blood alcohol concentration over time in somebody who has two different drinking episodes. So if they start out at a 0 blood alcohol concentration and they have a drink and then they stop, so they're going to absorb that alcohol. That's the absorption phase, which I abbreviated ABS. They're going to reach some peak blood alcohol concentration from that drinking episode, assuming that they haven't drank any more. That's going to take, on average, 30 to 60 minutes. And then they're going to be eliminating from that point on, unless they drink again. So say they then decide to have a really large drink. Now they're going to start absorbing that alcohol, take another 30 to 60 minutes, reach some peak, and then start to eliminate. So it depends where you're at on that chart. So for example, in my 0.6 case, it's possible the guy had alcohol in his stomach and hadn't actually even finished absorbing all of the alcohol at the time of the incident because he was then deceased. Or maybe he had, and he was in elimination. There are some things we can do to tell, but I don't know for that particular case.
Okay. And so in general, you would agree with me that based on your example and the chart you provided, that if someone consumes a large amount of alcohol shortly before their death, that a toxicology report would likely show a significantly elevated blood alcohol concentration consistent with heavy drinking, as the alcohol wouldn't have had time to metabolize fully in the body before the death if the death happened shortly after the heavy consumption. Fair?
If I'm understanding you correctly, yes. So if somebody's been drinking and they die before they have fully absorbed, what you're going to see is only what they have absorbed up to that point, which could be an elevated BAC.
Okay. You also discussed post-mortem redistribution, that's PMR. You primarily focused on cooling and dealing with that. How does warmth impact it?
Well, particularly for alcohol, warmth can exacerbate it and can lead to decomposition, which adds that second layer for alcohol of potential variance.
What do you mean by exacerbate?
So you can have both postmortem redistribution and decomposition. They're not, again, mutually exclusive.
Okay. So when you're talking about refrigeration or warmth, what type of temperatures are you dealing with?
So normally when we're talking about refrigeration, that would be, if somebody's body is taken to, say, a coroner's office, they have a cooler. I don't know the exact temperatures that they keep it at, but bodies that are cooled as a preservation method in preparation for autopsy has been studied for PMR versus, say, room temperature versus, somebody in Florida in the heat of the summer with no AC, maybe outside or something. So you have a whole range of possibilities there.
Okay. Have many studies dealt with arson?
Not a ton. I see more burned bodies in car crash cases generally, although, there are some out there.
So in terms of this post-mortem redistribution, you would agree with me that if a body got up to, say, 1,500 or 1,900 degrees, that could impact the toxicology.
Right, and as I mentioned, I've seen both increased and decreased blood alcohol levels in burned body cases. I don't know if they were specifically arson, though.
Okay. And it would also matter when the last time that person drank and where they're at on your peaks. Right? Now, as we get up the Dabowski chart for these additional stages, you would agree at a certain point, a person can begin to what's commonly referred to as pass out.
Yes.
What does that mean to you?
So passing out is not being asleep. It is a state of unconsciousness that is the body's self-defense mechanism to alcohol poisoning. So you're basically being rendered unconscious as a mechanism to stop you from consuming any more alcohol because you have poisoned yourself.
Okay. And a person would still be breathing?
Yes, otherwise they're in the death one.
In the death, yep, thank you. But a person can also become unconscious from other aspects rather than just drinking alcohol. Fair to say?
Oh, sure.
Physical impacts.
Right.
And you've already agreed that the combination between alcohol and those physical impacts would be something that would be consistent, that a person with higher BAC and those physical impacts, that could lead to unconsciousness.
It could.
Those are my questions. Thank you, ma'am.
Thank you.
Thank you. Any redirect examination?
No, thank you.
All right, thank you. Ms. Zerfer, I have one question, just to clarify it for myself. When you use the term decomposition as it's relevant to your analysis, are you only referring to, I guess, typical decomposition based on natural processes, or does that term also include atypical decompensation by fire or other actual direct injury or impact to the body?
Yes. So when I am talking about decomposition resulting in potential elevated blood alcohol concentrations, I am talking solely about the natural process over time of a body decomposing unpreserved, which can then result in the production of alcohol. That's it.
Thank you. Any follow-up question based on the court's question from the defense?
No, thank you.
Any follow-up question based on the court's questions from the state?
No, Your Honor.
All right, thank you. Ms. Zerfer, you can leave the witness stand. Thank you.
Thank you.
All right. The defense may call their next witness. If you wish to approach, you may do so as well.
Your Honor, we would like to call Detective Johnny Blair, please.
And I'm sorry, Blair?
Yes.
All right, thank you. Go ahead.
Thank you.
Thank you. Sir, if you'll please come forward and just stand in front of the witness stand. And sir, before you sit down, if you'll raise your right hand. Sir, do you swear or affirm under penalty of perjury that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth? Thank you, sir. Go ahead and have a seat. And Ms. Trujillo, you may begin when you're ready.
Thank you. Your Honor, could I borrow a pair of scissors? I think we might be cutting some things.
Do we, maybe, probably. Okay.
Can I approach?
Yes, go ahead.
Good afternoon, Detective Blair.
Good afternoon.
Thank you for coming back. Kind of want to leave off a little bit where we were earlier. Last week?
I believe so.
Okay, couldn't remember. About kind of what you had seen at Mr. Dickerson's home, okay?
Okay.
Obviously, stop me if you don't remember. We had kind of talked about you collecting a pumpkin beer can in the house when you were searching Mr. Dickerson's house. Do you remember that?
I do, from the bathroom trash can.
Yes. I want to show you now what's been marked as Defense Exhibit H. And before I do that, you did not, when you were at Mr. Dickerson's home, you were searching with other officers. Is that fair to say?
Yes.
Okay. And are you aware of the other things that other officers had found when you were all at the home together?
At the time, I was. Now I do not know.
Okay.
Who collected what.
No, that's okay. Not necessarily who collected what, but are you aware of just what was collected, I suppose, from the home?
Generally, yes.
Okay, thank you. I'd like to show you what's been marked as Defense Exhibit H.
H. All right, thank you.
Can I approach?
Yes, go ahead.
And Detective Blair, are you looking at pumpkin beer cans?
Yes.
Okay. Were these, if you're looking at Defense Exhibit H, can you see a label on, on the, I guess, the bag, the plastic bag entirely?
Yes.
Now, Detective Blair, did somebody else collect those pumpkin beer cans?
They did. I was with them.
Okay, so do those look familiar to you?
Yes.
Okay, Your Honor, we'd ask to admit Defense Exhibit H.
All right, I will accept into evidence Defense H, and you may publish at your discretion.
Thank you. I will just approach and move it out of the way if I could. So Detective Blair, those were 3 additional pumpkin beer cans?
That's correct, from the exterior of the home.
The exterior of the home, correct. Okay. Did these look burned to you at all?
No.
And did you, I understand that we talked about this before, but you do not test things for serology. Are you aware if any 3 of those beer cans were sent to the Colorado Bureau of Investigations for serological testing?
I don't know.
Okay. All right. I want to now show you what's been marked as Defense Exhibit N. Okay. So Defense Exhibit N, does this look like the wallet that was collected from Mr. Dickerson's car that was in the garage?
Yes.
And you were present for that, right?
Yes, I was.
Your Honor, we would move to admit Defense Exhibit N.
I'm sorry, N?
N as in Nancy.
All right, thank you. Any objection to N?
No.
The court will admit into evidence Defense Exhibit N, and you may publish at your discretion.
Thank you. Detective Blair, I'm actually going to ask you to open that.
Okay.
And I think we can do the sealed end where the cards are, so you're right.
Here.
Yes, please. If you could please cut that open, I'd like to go through that. All right, so if you could take out those cards, please. Are you able to kind of move them out?
Wallet.
Great, thank you. If you could kind of, go through those cards, can you find a gold kind of card that's a gift card in there? If you wouldn't mind looking through that.
The last one.
Perfect. That gift card, it's a MasterCard gift. Is it a MasterCard gift card that says like $100 on top?
Yes, it is.
Okay. Is there also a Walmart gift card in there?
Yes, there was.
Thank you. Looks like there's a King Soopers card in there.
Yes.
Okay. Are there other gift cards in there? If you could go through those.
There's a Sprouts gift card,
Thank you.
Fuzzy's Taco Shop, J.C. Penney, Loaf and Jug, 2,
Thank you.
Cane's Chicken, Raising Chicken, Schrader Oil, another Sprouts, believe, and a Radio Shack.
Thank you. And so did you and other officers find this when you were searching through the car that was in the garage, the Elantra?
Yes, that's correct.
Okay. And so there's other items incorporated in Defense Exhibit N, right?
Yes, documents, receipts, and some paperwork.
Okay. So other things just generally collected from the car, right?
Yes.
Okay. Thank you. And then finally, I just want to show you what's been marked as Defense Exhibit O. Your Honor, I believe we need to approach.
Oh, okay, go ahead.
Okay. So showing you what's been marked as Defense Exhibit O. Do you see that?
I do.
Okay. Are these, we had talked, I think last week, and you were shown a photo of all the kind of different pipes and things that were found in the house, right?
Correct.
Okay. Is this essentially the physical items that we saw in the photos?
Yes.
Okay. And it fair and accurate to what you had seen in Mr. Dickerson's home?
Yes, they are.
Your Honor, we'd move to admit Defense Exhibit O.
Any further record from the state?
No objection.
All right, I will admit into evidence states O, and you may publish at your discretion.
And Detective Blair, just to clarify, those pipes, all the like the silicone and everything, that was all found in Mr. Dickerson's home, correct?
Yes, I believe so.
Okay. In the living room, in the bedroom?
Yes.
Okay.
Possibly a closet.
Okay, but inside the house, I suppose?
Yes, correct.
Okay. And the only time that you were there was after the house was burned?
Yes.
Okay. I just have one more question for you. When you were in the home itself and you were searching the house, did you see a laptop that was in a bag that was like in the living room area?
Yes.
Okay. And you had seen that, I suppose, like not move from a car or something like that, correct? Like it appeared as if where you found it, it just was.
I believe it was in the living room, so it was burnt and melted.
Right. Okay. Sorry. I guess to clarify, versus you, we had talked about the bedroom and some things on the bed, and you were looking at the mattress and lifted those items off, and it was, white underneath, right? Suggesting that those were there before the fire, right? Is that fair?
Yes.
Okay. But you hadn't seen anything to suggest otherwise, that you just saw that laptop in a bag that was melted in the living room, right?
Yes.
Okay, thank you. Nothing further.
All right, thank you. Any cross-examination for Detective Blair?
Sure. Detective Blair, do you know why you were called back today instead of handling this?
Objection, relevance.
All right, I'll sustain that objection.
Detective Blair, you were asked about those pipes, and specifically when you testified previously, do you remember that there were pictures associated with where you found them?
Yes.
Were those all in his bedroom?
The pipes?
Yes.
No.
Where were they?
I know there was paraphernalia in a hall closet, some on the bed, and then believe there were some in the living room. I don't know exactly where, but living room area.
Okay, describe where.
It was like a wire shelving unit that seemed to have pipes in the
Okay, so like
around it.
up, elevated.
Everything was on the ground when I was there, but it would have been in on a piece of furniture.
Okay, so it would have been elevated at the time of the fire.
Possibly.
Objection calls for speculation.
Well, where exactly did you find it?
Your Honor,
So,
I ask the court to rule.
and I'll sustain the objection. If you want to rephrase, Mr. Braley, go ahead.
Sir, can you tell us?
I don't know where they were before the fire.
Okay, where were they when you actually found them, I guess, is what I want.
Objection asked and answered. Detective Blair argued that they were on the
I'll
floor.
allow the clarification.
Like, can I go approach? Do you remember the defense giving you pictures?
Yes.
Do you know which pictures? Do you want to look through them?
Yes, I can look through them.
Handing you the whole stack. You tell me, you'll just identify which one.
Okay.
Do you need to look through them again?
I don't believe the living room photos are in here.
Okay.
Only the bedroom.
So those are the only photos? Bless you. Can you tell us with your photos? Would you like to look at the prosecutions?
Yes, I can look at those. I'm trying to recall if we looked at the ones found in the living room.
I'm just trying to ask where they're at because they're all packaged together. Is that fair?
I understand.
Can we give you a stack, sir? I'll take these back. They're not in these, right? Maybe we can help with this, sir. 42, are you to that?
42?
Yeah.
The picture of the bloody clothing?
Let me approach with 45. Maybe that will help when it's been cleared.
Your Honor, if I could see what the prosecution is showing.
Sure, can you just,
Yes, but can I see the photo of 45? Right, but that's just labeled.
This is literally exhibit 45 that he's looking at. Sir, I'm simply asking if you know where. If you don't know where, you don't know. I just wanted us to orient where this is at and which pipe.
I don't recall, and I believe Officer DeSandre did collect these in the living room.
So you don't have personal knowledge.
I don't.
So to be fair, you don't have personal knowledge that there is a pipe collected in the living room. Because you didn't personally do it. And you don't have a photo provided to you of that, do you?
Is there a
Mr.
question
Fraley,
and answer?
let him enter. Let him-
That's true.
Is it possible that it was collected there?
Yes.
Okay. And ultimately, where do you think it was collected? I'm not trying to be difficult for you.
Positive they were collected off the bed, and I'm positive there was some in a hall room closet, and I believe some were collected from the living room. I do not know where.
Potentially on a stand or something that you said was metal.
Correct. Like a wire basket. That's what I recall.
Okay. And describe, I guess, how it would be impacted, that room of stuff falling.
So the living room was 6 inches to a foot of rubble on the ground.
Is that very different than his bedroom
Yes.
or the hall?
The living room sustained the most damage during the fire.
Okay. Those are my questions.
Any redirect?
Just briefly, please. Thank you. Detective Blair, you just testified that you couldn't remember exactly what you found in the living room. Is that fair?
Yes.
Okay. Would it refresh your recollection to review your report?
Yes.
Okay, it's sub 24. All right. I will be looking at page 261, if that's helpful. And I marked that paragraph. If you want to just review that and let me know when you're finished. That refresh your recollection?
Yes.
Okay, thank you. So you did see a metal wire shelving unit, right?
Yes.
And there were glass pipes in there?
Yes.
Okay, thank you. Nothing further.
All right, thank you. Detective, you can leave the witness
Can I
stand.
ask one question, Judge?
Briefly, yes.
Did she read all of that to you right there? Can I approach?
I read a paragraph.
Okay. Can I approach with that same paragraph to make sure it was read to you properly?
Your Honor, I don't believe this is proper impeachment or refreshing.
Can the parties approach?
Sir, in that shelving unit, did it say that the pipes were trapped in the wire drawer?
Correct.
What does that mean?
Contained within the wire drawer.
Okay, thank you.
All right, thank you. Detective, you can leave the witness in.
Thank you. Did you need me to leave?
Yeah, you could just leave us. Thank you.
From the defense, do you have a quick witness available, or is this an appropriate time to recess?
It'd be an appropriate time to recess if we could.
All right,
Thank you.
All right, ladies and gentlemen, we'll go ahead and recess for the day. I want to remind you that until the trial is completed, you must not discuss this case with anyone, either in person, using the internet, or by any other means. This includes members of your family, people involved in the trial, other jurors, or anyone else. If someone approaches you and tries to discuss the trial with you, or if you see or hear anything about it, even accidentally, please let me know about it immediately. You must not conduct any research, undertake any investigation, or otherwise obtain information about the case from an outside source. You must not read or listen to any news reports or internet information or other electronic sources about the trial. If there has been or is any news coverage of this case, you must completely disregard it. Your verdict must be based solely on the evidence presented in the courtroom and the law as I instruct you. And finally, it is especially important that you do not form or express any opinion on the case until your deliberations at the end of trial. With that, we'll be in recess until tomorrow morning at 8:30. Please rise for the jury as they leave. All right, thank you. Please be seated. All right. And from the defense, before I go off the record, I just wanted to ensure, do you need me to address Curtis at this time, or is that something that we'll do tomorrow at some point?
We can do that tomorrow.
Okay.
Thank you.
All right. The court will be in recess until 8:30.
Thank you, Judge.
Thank you.
Sorry.
Oh, no.
That's okay. You do have to tea.
I don't know how to do this. You tell me.
I'm sorry, I'm just kidding.
Well, actually, yeah, because they're, so they want to be out of your.
Okay, whatever.
I just feel like this needs to go into the appellate record, right? Sure. I don't want anything, it's also open. So I was told that we would always care about preserving this.
I don't, yeah, no, I do.
Yes.
Don't know what.
No. I mean, I'm fine with that, but like, yes, that's.
It was, we were just, the ceiling, we're trying to figure that out.
Okay,
But yes.
that's what I was thinking. We don't want to leave that, have all these cards falling out.
Yeah, just like all those gift cards. I don't know about Radio Shack anymore. Okay, see you in a bit. Okay, yeah.
I mean, it's kind of weird for us too, because this is like after the fact, so we're not used
Yeah,
to
no,
like,
no,
once
no,
it's
no,
over
I
the
think
trial.
we should-
It was weird to me. And he didn't like that.
Yeah. Well, in a few cases. When I say taught.
Yeah.
Courtroom.
Okay.
Yeah, that's the way you want to be taught.
Yeah.
sure if that is our it is property.
Together. Yes, because I had one and then I just started.
Yeah.
As I did it at like 8:11.
Yeah, so